Your full name appears as it is supposed to in your profile. All delegates will be muted during the meeting. If you wish to speak, use the Raise Hand feature. If called upon, all comments will be limited to 3 minutes. Use the Raise Hand feature to advance and second a motion to approve a report. When voting, a poll box will appear on your screen. Please identify your vote at that time. If you abstain from a vote, you must email Kim at NYSBA separately so she can document your abstention accordingly. The chat feature will be disabled for this meeting and for future House of Delegates. This will allow for proper speaker recognition and reinforce all necessary comments be recognized and shared appropriately as we would during an in-person meeting. Motions made from the floor during the meeting must be typed out using the Q&A feature. As previously mentioned, be sure to use the Raise Hand feature to advance and second a motion. If chosen to speak, remember to turn on your camera and unmute yourself. We cannot guarantee that every person wishing to speak will have the opportunity to do so. We thank you for your patience and understanding. Thank you for listening. Now sit back, relax, and enjoy the meeting.
Good morning, everyone, and welcome to the House of Delegates, June 12th, 2021 meeting. Welcome to our virtual meeting. We appreciate your participating in today's meeting. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. You may be seated. I would like to welcome the new members of the House of Delegates who took office on June 1st of this year. I would like to remind you that this meeting is being recorded. The recording will be posted online and will be available to the members of the association, the members of the public, and the members of the media. Please note that delegates will be muted unless selected by the chair of the House to comment or from your virtual seats. Please use the raise hand button to note that you wish to speak from the floor. If selected to speak, as has been our practice, we ask that the delegates follow these guidelines in order to promote an orderly discussion and debate. Delegates should identify themselves and their affiliations. Delegates should speak only once and limit their remarks, please, to 3 minutes. This means if you have more than one question, please include all your questions for the presenter in your initial presentation. Questions should be directed to me as the chair of the House. Delegates should refrain from procedural motions until the substantive discussion is completed. In this regard, a delegate may rise to speak to a motion on the floor and advise me that he or she intends to make a procedural motion at the appropriate time. I will then recognize you to make that motion at that time. For reports, which discussion and votes are required. If you would like to speak to a report, please use the raise hand feature to be recognized after the presentation of the report is completed. After the discussion is completed, you will be asked to complete a poll that will appear on your screen. Select aye, nay, or abstain, and then click submit. You will have 30 seconds to vote. If you abstain, please email Kim at NYSBA.org so that she can record your abstention. The results of the vote will be displayed on your screen. Please note that to adhere to the rules of the House of Delegates and for proper recognition of speakers, the chat feature will be disabled for this meeting and for all future House of Delegates meetings. I now move to item number 2 on the agenda, approval of the minutes. Do I have a motion to approve the minutes?
Second.
Are there any discussion or corrections or deletions? Seeing none, the minutes are accepted as distributed for the April 10th, 2021 meeting. I would now like to move to item 3 on our agenda, the installation of T. Andrew Brown as president. Andrew took office as the 124th president of the association on June 1st, 2021. Since this is the first House meeting with the association this year, Andrew will now formally take the oath of office as president. I would like to recognize Chief Judge Janet DeFiore to administer the oath to Andrew.
I, T. Andrew Brown,
I, T. Andrew Brown,
do solemnly swear
do solemnly swear
that I will support the Constitution of the United States
that I support the Constitution of the United States
and the Constitution of the State of New York,
and the Constitution of the State of New York,
and that I will faithfully discharge
and that I will faithfully discharge
the duties of the office of President
the duties of the office of President
of the New York State Bar Association
of the New York State Bar Association
in accordance with the association bylaws
in accordance with the association bylaws
and to the best of my ability,
to the best of my ability,
so help me God.
so help me God.
Congratulations,
Thank you,
President.
Judge. Thank you.
Please join me in congratulating Andrew.
Thank you, Chief Judge DeFiore, for installing me as the next president of the New York State Bar Association. My fellow delegates, friends, and colleagues, it is a great honor to stand before you as the new president of the New York State Bar Association. I'm humbled with this opportunity. I'm reminded that there were only 123 men and women who had the good opportunity to serve as president of this association before me. And I am proud to follow past President Scott Carson. I've had many opportunities to talk to other past presidents over the past couple of months and even the past couple of days. And I found myself thinking back to some of the things that they've said as I thought about standing up this morning. Many told me that it was the highlight of their careers, and many told me that it was a highlight, one of the great highlights of their lives. So inevitably, I found myself thinking back over the span of my life. And I found myself thinking back to the earliest of my days. Days that were very unlike the life I live now. Days that were burdened with many hardships, many hurdles. Having grown up Black and poor, but that today makes it so much sweeter to be standing here as president of the New York State Bar Association. And no doubt, my parents, who are long since deceased, are looking down proudly and beaming upon this moment. To returning delegates, it's nice to see you again. I want to commend you for the good work that you do on behalf of this Bar Association, and I look forward to continuing that good work over the coming year. To new delegates, I welcome you. I look forward to working with you and doing all that I can to encourage you to give all that you can to the service of I want to thank our staff, knowing that this year and my successes this year will be largely dependent on them. I look forward to working with them, especially our executive director, Pam McDevitt, and their senior team, but also getting to know those down through the ranks. Those are the people that make us the success that we are. I also want to acknowledge our new committees and section chairs. Many of you have begun your term just in June. I look forward to working with you, and I want to congratulate my fellow officers, especially President-elect Sherry Levin-Wallach, Treasurer Dominic Napolitano, and Secretary Taya Graves. And I want to particularly thank immediate past President Scott Carson. I look forward to continuing to serve with you, Scott, over the coming year. And I thank you, Scott, on behalf of our membership for the leadership and stewardship that you have demonstrated over this past year, leading us through one of the most difficult times in our history as a country and as a bar association. It's hard to stand up and talk about much these days without reflecting upon the past 15 months. That has shaped us, that continues to shape us, and it will continue to shape who we are as a bar association. So let us turn and look back over these last 15 months. 15 months in which the practice of law and indeed our daily lives have changed perhaps more so than in the past 15 years. This past year has taxed us, our nation, our state, our profession, our communities, in ways before unthought of. We've more closely examined our lives, our relationships, searching for meaning and mission and what really matters. Coming out of this pandemic, we now face a time of further reflection, a time of reckoning, a time of renewal, and a time to reimagine our highest ideals. Physically, socially, emotionally, and for many financially, we have been stretched thin. We have been challenged, and we're tired. We witnessed levels of unemployment, isolation, and indeed forced societal change, perhaps unseen before in our lifetimes. We also witnessed democracy stretched to a near breaking point. We witnessed societal, social upheaval, discrimination, injustice, ugly reminders of the stain that still blights America and prevents many from the true promise of the American dream. This, my friends and colleagues, is the history that I inherit. This will be the backdrop to shape my presidency. As eager as we are to move ahead, trying to put these times behind us, it is imperative that we do not close our eyes to the revelations and lessons it brought, no matter how difficult that may be. We find ourselves indeed on the cusp of great opportunity. Let's not fail to take advantage of it. The twin crises, the coronavirus pandemic and social justice as it relates to law enforcement, combine to expose long-standing inequities, and it is far past time that we address them. I will dedicate my presidency to careful attention and action on these matters. We will seek change. Changes sought will not come easy. In fact, many cases, entire systems, policing, healthcare, education, even our courts require significant reimagining and retooling. As lawyers, we have indeed a role to play. We are uniquely positioned to assist in this endeavor. The restrictions imposed as a result of COVID-19 crisis exacerbated the already considerable difficulties faced by many of the most vulnerable members of our society, including access to justice, at the very foundation of our democracy. Shuttered courts and virtual proceedings presented additional barriers to those who do not have easy access to the internet, cannot afford representation, and for whom English is not their first language. But there are also advantages to expanding virtual proceedings. for court employees and attorneys alike. Now that there is light at the end of the tunnel and we see reopening of our courts and offices, it is time for us to take stock of the changes that occurred over the past year and determine what has worked and what has not. What do we keep and what do we go back to? Both the association and the profession must reflect and reimagine how to safeguard and strengthen our futures. And where necessary, we cannot fear reinvention. We must embrace the opportunity for change. And I would submit that if we look back on history, much of the greatest progress had in this country and by organizations such as ours followed some of the very worst of times. The work of which is of the utmost importance to the strength and future of our association. Task Force on Racism, Social Equity, and the Law, with an eye toward building on the work of the association. Transient regulations, laws, structures, and policies that are collectively holding us back as a society from achieving true equality. We will strive to see every issue this year and tackle every issue through the lens of equity, as we know all too well that racism and injustice pervades almost every aspect of our lives. And it will not stop there. We will look beyond race. More than 100 years since the ratification of the 19th Amendment, we know that much more needs to be done to advance gender equity. I will look for opportunities to do that. We must also address those who suffer stigma and abuse as a result of their sexual and gender orientation. Across the nation, we're seeing an alarming rise in efforts to curb the rights of individuals simply because of the way they choose to express themselves. This past year, there was a record-breaking year for anti-transgender legislation, with 33 states introducing a variety of bills targeting the freedom of this vulnerable population. With this reputation as a progressive leader, New York cannot and should not speak out, or should speak out against these prejudicial efforts and set the standard for the equitable treatment of all individuals under law. State-level initiatives like those that target transgender are born at the ballot box. The free and unfettered ability to vote is a fundamental right, and it too is under attack. This past year has brought a rise in efforts to undermine this inalienable right, starting with the pre-presidential push to discredit the outcome of the 2020 election, followed by the unprecedented January 6th attack on our nation's capital. Now we see states across the nation engaging in a wholesale push to restrict voting rights and access. This assault on our democracy has been largely targeted against Black and brown persons who have long fought for the franchise and access to the ballot box. New York, thankfully, has done a lot of work to advance and improve access to the ballot box in past years. We should be a beacon of hope and a shining example of how to encourage participation in democracy, not limit it. The association too has a role to play here. That is why I will establish a task force focused on voting rights and charged with developing recommendations to further safeguard this most important tenet of our democracy. I will also build on the initiatives of my predecessors to continue our important work in recognizing the importance of mental health and well-being. We will continue to address these issues. Our profession has long failed to address the plight of mental health and well-being and how it affects the livelihood of our profession and our friends and our families. Now, as we come out of the pandemic, I sadly believe that we probably have more work to do in this area than ever. I'm pleased that the Task Force on Attorney Wellbeing, appointed by President Carson, continues to do its good work, and we all look forward to its report in October addressing some of these issues. I am aware that the agenda I have spoken to is far-reaching and ambitious, and there will undoubtedly be additional issues that will arise during the coming year that will need my attention and the attention of us all as leaders of this bar association. But I firmly believe now is the time for us to tackle difficult and intractable issues or risk remaining relevant and responsive to members and prospective members and to the profession. I look forward to working with committees and sections to do most of the good work to be done over the coming year. Today, you will hear presentations on reports that were prepared by men and women who spent countless hours, some even years, preparing. This represents some of the best work that we can showcase as an association. I thank the leaders and the members of the groups responsible for working on these reports, and I look forward to continuing to work with you. Indeed, the events of the past year upended and unsettled us, but has also accelerated and mandated changes that arguably would have taken much longer to accomplish, but certainly would have come. Now that we are here, we must take advantage and reinvent ourselves as a profession, and certainly as an association. We will be different going forward. We should embrace that opportunity. There is no turning back fully to the way things were before. We must have the courage and willingness to make change and do things differently than have been done in the past. Those bar associations that have failed to recognize that are already slipping behind, and that will continue to be the case. Our proud bar association must remain at the forefront, recognizing this need for reinvention. I look forward to working with you all. Indeed, as the pandemic continues to abate, I look forward to being with you all in person in the not so distant future. In the meantime, do not hesitate to reach out to me. There is much work for us to do. I look forward to my year of service. Thank you.
Thank you, President Brown. I'm honored to serve as your president-elect this year. Before we move on to the reports of the House, I'd just like to remind the attendees that time has been allotted in the agenda for your presentations, as well as for discussion. I'd ask that you adhere to that time and pay attention to the timer, which sits in front of me on the podium or on the desk. Thank you very much. And at this time, I turn our attention to the report of our treasurer, Dominic Napolitano. Thank you, Dominic.
Good morning, everyone. Andrew, I am extremely proud, sir, to serve under your leadership this year, along with Sherry as president-elect and Taya as our new secretary. I know that you're going to have a fabulous year, and I look forward to every minute of it. Good morning again, everyone. I trust that everyone is well and healthy, and I look forward to seeing all of you, hopefully in the not too distant future, in person. I'm here to report today on the results of the operations of the New York State Bar for the 4-month period ending April 2021. Additionally, I will report on a few other events that have financial impact on this year and in years to come. The statement of activities you received show the end of April 2020 as compared to 2021. The reduction in revenue shows in large part is due to the annual meeting revenue that was not received this year. I will get into more detail about the annual meeting shortly. I'm finally very proud and happy to report that we have good news on our dues front. Dues revenue through April 2021 is $8,996,000, which is about $139,000 more than it was last year at the same time. As noted in the slide that you're seeing on the screen, the 2020 dues revenue includes dues that were deferred in the amount of $234,000. We do not and will not be deferring dues in 2021, but rather we will be recognizing the revenue when it is collected. As I noted in February, we had collected in February approximately 94% of our budgeted dues. As of the end of April, we have exceeded our dues budget by $234,000. I do want to point out, however, that we had substantially reduced our budgeted goal for dues in 2021 due to the uncertainty of the pandemic. While we still have a long way to go to surpass our dues collection for 2020, which was approximately $9,290,000, I have faith in our new leadership and in all of you to bring that number to reality by the end of this year. Next slide time, please. On the CLE front, as noted in my April report, CLE had the best year of net revenue over a 10-year period in 2020. The move to virtual programming has increased attendance and decreased the expenses substantially. The CLE department, of course, should be commended for adapting to the new world so quickly and working tirelessly to put educational information out to all of you. This slide shows the 10-year net revenue of CLE as of the end of April. Although net revenue is down by approximately $200,000 this year, it is mainly due to a switch in live programmings and to virtual webinars in 2020. I do want to point out that this dues revenue recognition is based in part to the way we recognize income through Frontier. Previously, revenue was recognized when it was received, while we are now recognizing it on the last day of the event. And as a result, it appears that the revenue has decreased. Several scheduled meetings in April and March of last year of live programs had to be recalendared, and those registration fees had to be rescheduled then later in the year. The fee price for these programs was reduced, and the fee difference was refunded at the time of the rescheduled program. So we expect that the net revenue differential will decrease as we go through 2021. Additionally, as we are hopeful to move forward in this life that we now have lived, we'll be more careful to learn how things should progress going forward. I mentioned the annual meeting earlier. As you are aware, we held our first ever annual meeting virtually in January, and it was a complete success. This slide includes revenue and expenses for the New York State Bar activities. The association netted $466,000 in 2021, which is an increase of $226,000 over that which it was in 2020. In addition, the section's net revenue increased by almost $700,000 from 2020 to 2021. I want to point out that we had in 2020 more than $1,500,000 in expenses, and a good part of that was due to the Hilton. This year, we paid no more than $24,000 in expenses in the annual meeting. Okay. There are naturally some other items that will be coming up during the year, and I will report on them as they occur so that you are kept fully abreast of all of the financial issues of the association. We'll continue to work towards our best solutions. We have obviously some matters coming up with the foundation. You'll hear more about that shortly. We also have, as I reported as well back in February, that our USI contract is expiring at the end of this year. We're in the process of negotiating a new contract with the people at USI. So I will come back and report on that as well. And other than that, Ms. Chairperson, I offer the report for the House's consideration. I'll answer any questions if there were any.
Thank you, Dominic, for your report. Your report is accepted. Are there any questions? Okay, seeing no raise of hands, your report is accepted with the thanks of the House.
Thank you, Ms. Chairperson.
We will now move on to item 6 on the agenda. This is the report and recommendations of the Lease Negotiation Committee and the Finance Committee. As you know, last year, past President Scott Carson appointed a Lease Negotiations Committee to review the current lease of the Bar Center, which expires on December 31st of 2021. The current use of 1 Elk Street and the association's needs going forward, and the future long-term facilities lease. As has been reported in the media, the association and the foundation have signed a memorandum of understanding by which the association would remain at 1 Elk Street. A provision of the MOU calls for the association and the foundation to explore joint fundraising activities. And President Brown has asked me to head the association's efforts in this regard. The report will be presented by David Miranda as Chair of the Lease Negotiations Committee and Sandra Rivera as Chair of the Finance Committee. Please press the raise hand button if you would like to speak from the floor of the House after the presentation of the report. At its meeting yesterday, the Executive Committee endorsed the resolution as amended, and I remind you that an amended resolution was distributed, I believe it was last evening or received early this morning. Thank you. You may proceed.
Okay, good morning. Thank you, Madam Chair. Good morning to everyone. I am very pleased to appear before you today to deliver what is intended to be the final report of the Lease Negotiation Committee. And I want to thank the other members of our committee, Michael McNamara and Sandra Rivera, for their devoted attention to this issue over the last 8 months. We are very pleased to have a happy resolution of this issue, and we can move to the first slide. So, you know, I was hoping to tap into the nostalgia for things that were great in the 90s with this slide to hopefully, you know, loosen you up a little. We can go to the next slide, because this is the one where they agreed to a memorandum of understanding. So for those of you who are new to the House and are not fully familiar with the issues that have been discussed, you should be extremely grateful and thankful. We have for your reading pleasure a 36-page report that outlines all of the issues that have gone into this. That's supplemented by a 714-page attachment, which I'm told makes this the largest report that's been delivered to the House of Delegates. I think the report's important because it memorializes a lot of hard work that was done and will be able to be used by the association in the future. I want to tell you just briefly how we got here. As you were just told, our lease expires at the end of the year. Under the lease terms, the association pays the foundation, who owns 1 Elk, $300,000 a year in rent. In addition, the association pays all of the maintenance, utilities, taxes, repairs, something that's a little bit unusual for a tenant. We basically operate as owner. The cost of all of this, the $300,000 plus maintenance, repairs, taxes, et cetera, last year came to $1.1 million. As we are contemplating a future lease, we realized and did some investigation and realized that there were substantial renovations that were necessary to continue to keep the 1 Elk Street as the long-term home of the association. These renovations included substantial upgrades to the heating and ventilation system that were in the range of $1 million, substantial repairs of the roofing. For those of you who have been at 1 Elk, you understand that accessibility is an issue. There would need to be upgrades for accessibility in our elevators, in our restrooms, and for an association that prides itself and advocates for diversity and inclusion. It is of crucial importance that our home be accessible to our members and to our guests. And so all of those issues were brought up, and we have estimates for all the repairs in the millions of dollars. We estimate that over the next 3 years, approximately $4.8 million in renovations would be necessary. We brought this obviously to the attention of the foundation when we were discussing the possibility of a long-term lease to continue. And the foundation has, advised us during the course of these negotiations that they were unable to pay for the renovations that were anticipated because of the good work that they do with the money that the foundation gets to provide it towards charitable services and legal services throughout New York State. And that to have to pay for the renovations certainly would be something that would put a substantial damper on the good work that they do. So we continued to discuss possible alternatives, and none of the alternatives were really something that was acceptable. Throughout this process, I want to commend the leadership of our association for being fully transparent, both about the costs of remaining at 1 Elk and about the negotiations with the foundation. We have brought literally everything to this house. We've made multiple presentations, hundreds of pages, hours of debate. And this house knows that the options that we had none of them were really good. One was to remain under the current terms of the lease, as I indicated, would cost the association $1.1 million, and then also have to pay for the renovations. That was found to be unacceptable. The other was to leave 1 Elk. This was very divisive, as you can imagine. Where would we go? Would we rent a place somewhere else? Would we build a new home somewhere else? And what would the relationship with the foundation be if we were to leave 1 Elk? We did look into alternative space. Certainly nothing definitive was determined, but the cheapest space that we could find would cost in excess of approximately $700,000 a year. So the cost of leaving was not zero. We would have to go somewhere, and that somewhere would cost a substantial amount as well. The message from this house to the leadership and to our committee and to the foundation was, we need to sit down and get this done. We need to work on this for the good of both organizations. And I want to give credit to the leadership of both organizations for listening to you, to listening to this house about what needs to be done. And we did, and we worked hard. And I'm going to talk a little bit later about some of the people from very different points of view who came together to get this done. But let's talk about what we have. I want to go to the slide about the memorandum of understanding. Under the agreement that we have come to, ownership of 1 Elk will be transferred from the New York Bar Foundation to the New York State Bar Association. In exchange for that, the association will provide office space for the foundation staff, as it has done since the foundation was formed. The association will also provide in-kind services to the foundation to ensure that the foundation's operational expenses can be maintained. And that's something I want to point out that the association has been providing now because of our relationship with the foundation for many years. There's no agreement, now there is, but we've been providing hundreds of thousands of dollars of in-kind operational expense services to the foundation in the range of administrative services, human resources, marketing, advertising, technology. And we do that because the foundation is so important to us. Under the memorandum of understanding, this is specified to provide comfort to the foundation that regardless of what happens with the building, that our relationship will stay strong and the foundation will thrive. So in the memorandum of understanding, for the first 2 years, there's in-kind services of up to $300,000, which quite honestly is a little bit more than has been provided in the past. And we wanted to make sure that as the foundation transitions during these next 2 years, that they would have all of the in-kind services that they needed. After that, after those first 2 years, it would be reassessed. And we would want to make sure that the foundation got what it needed, but with the expectation that after that, it would go down to hopefully $250,000. The association would also bear the cost for the renovation and maintenance of the building. This has all been provided to the House before in great detail. Those numbers have not changed. The $4.8 million that we expect over the next 3 years still remains the same estimate. The association and the foundation will work closely in joint fundraising in order to meet common goals. This memorandum of understanding is contingent upon approval of the association's House, the foundation's board, which has already approved it, the New York State Attorney General's office, because this is going to have to go through the Attorney General's office because it's the foundation's a 501c3. We have been working closely with the Finance Committee throughout this process. The association is engaging counsel to work to ensure that we can get the necessary approvals from the Attorney General. We're also engaging counsel to look into the potential tax implications and to make sure that all of this is done properly and to the benefit of the association and its members. There's some, I want to say something about the leadership here. They and in particular, past President Scott Carson and your current president Andrew Brown insisted that in this memorandum of understanding that this memorandum of understanding be contingent upon the approval of this House. This was a promise that was made by leadership, and they were insistent that this go through the House. And I certainly hope that in that spirit, that the House approves it, so our association and the foundation can move forward. This will be the first step so that we can now go forward and bring and keep our two organizations together and remain at our long-term historical home at One Elk. Our association, we looked into what other associations, state bar associations have. 95% of them have their own building. Our association, the greatest state bar association in the country, deserves to have a home that is consistent with the importance that this association has. I want to go to the next picture here. So just to take a trip down memory lane, our forebears worked extremely hard to find the perfect location for our home, for our permanent home at One Elk Street, nestled perfectly across the street from the Court of Appeals and across the park from the Capitol. When a guest comes into our home at One Elk, they are impressed. It is an impressive location, consistent with the prestige of our association. I have a picture here of some of the past presidents, because I was told that we would get the support of the past presidents if I showed their picture. So I think we got about 20 votes right there. So many of the people pictured there worked very hard to both in support of One Elk and in support of bringing these organizations together. We can go to the next picture. I know nobody in the House made me any promises, but I thought maybe if I showed a picture of you guys, we'd get your support too. You know how beautiful and important that great hall is to us. You know the feeling that you have when it's full and packed, and there's an electricity in the air, and there's a history about it that's important to all of us that we're not going to get in an office park. We're just not going to get it. So yes, there's a cost to this. There's a cost to leaving. There's a cost to not having this type of wonderful location. We can go to the next slide. So it's a historical place. That's what this slide tells you. So what about the cost? Well, over the next 10 years, we're going to save $3 million. We're not going to pay rent. And as I said before, we were paying, including rent, about $1.1 million a year. Take the rent away, that's $800,000. $800,000 sounds a lot like the cheapest alternative, which was $700,000. And we get to stay at One Elk, not move to an office park. So that's good. We have a print shop that is year by year gradually diminishing because of the digital age, which apparently the New York State Bar Association is also entering into. And the print shop, after 2024, our lease on the print shop ends, and we're going to plan on moving our reduced print shop into One Elk. The print shop costs us $239,000 a year in rent. We'll have savings. So look at that. We're at 4.6, pretty darn close to what we need. So there's other benefits. There's more. There's other benefits to staying at One Elk. We have the possibility of leasing part of the building for additional revenues. We only need about 25 to 27,000 square feet. The above ground square footage of One Elk is about 44,000 square feet. So we might have some extra space that we could lease for additional revenues. In addition, our investment in the building will now inure to the benefit of the association. It'll inure to the benefit of a building that we now own. And as I said before, the alternative to being at One Elk isn't zero. We have to be somewhere. And as I said, the alternative, the cheapest alternative is very close to what we'd be spending each year now. And I want to say something else about the people that were involved in this. I need to thank a lot of people. And I know sometimes we get tired of hearing we thank everybody and pat each other on the back. I want you to listen to this part. This is the most important part. The names that I mention are people that you know, people that have devoted hours to the association that they care so much about, and the foundation that they care about. You know, throughout this, I kept hearing, you know, how divisive this topic was. I can tell you that being in the middle of it, that everybody was operating in good faith. And for something that was supposed to be so divisive, I have never seen so many diverse leaders working together for the same common goal. I want to thank all of the officers. All of them worked hard on this. I want to thank the Finance Committee. I want to thank John Gross of the Finance Committee. And I want to thank past President Michael Miller for stepping up as acting finance chair when he was called upon the association to step up. And he stepped up and was extremely helpful in moving this forward. I would like to thank the foundation and their leadership, their past president, Leslie Rosenthal, for her work on bringing us to this part, to to the current president, Carla Palumbo, for her tireless efforts in working with us to get this done. I want to thank the Honorable Cheryl Chambers for her efforts to move this forward, and other members, James Barnes, Don Dorr, the entire foundation board, who have, all of whom were talking to the officers of the association to make this happen. I want to thank my counterparts at the foundation, past President Dave Shraver and Bruce Lawrence, for their efforts in this negotiation. I want to thank the past presidents of our association, many of whom were extremely helpful to getting this to where we are. One or two of whom who thought they were helpful to bring us here. I thank you all, regardless. A lot of people spent a lot of time to get us to this happy conclusion. And it is a happy conclusion. We can now focus on the wonderful reports, substantive reports that make this association great. And we can do so in our historic home that also makes us great. So I would like to call upon Sandra Rivera, the chair of the Finance Committee, to give input on the Finance Committee's perspective, and then I will make a motion.
Good morning. So it's always hard to follow, David, but I will do my best, and I will be quick because there's so much more that needs to be done at this House meeting today. So before I get started, I too just want to express the thanks to everyone, as David has mentioned, in terms of bringing us to this point today. In addition, I do want to thank the association staff who put in just as many, if not more, hours working to make sure that all of those pages, those 736 pages, were accurate and available to anyone in the membership who really wanted to see this information. And and you should have seen it. And so we're very proud to have that available. So thank you, Chris O'Brien. Thank you, Amira. You just did tremendous work. And I too want to thank the Finance Committee members who also were invaluable with their guidance and direction as we went through this process over months. And as well as to John Gross and to Interim Chair Michael Miller. They did really help provide the guidance to navigate and help the lease negotiation team work to get to this point. So I will just be quick. I just want to bring everyone up to speed as far as what the Finance Committee was doing throughout this process. For those who are on the House in January, you may remember that I reported on behalf of the Finance Committee the work that we were undertaking as we were looking at the current lease and what was the history, what were we spending over the last 10 years, and what were we anticipating spending over the next 10 years should we remain at similar lease terms. And as David had mentioned, it rounded out to about $1 million a year over the last 10 years. And what we were expecting going forward was the same, but then in addition, all of the renovations that you had heard about, which is about $4.8 million. And we're still sort of reviewing how, obviously if this were to go forward, we would have to figure out how we're going to pay for that, which falls to the Finance Committee. So I am happy to take on that hat and work with the Finance Committee members to work toward that, should this come to fruition. So that was in January. So we got a sense of the history of where we're going. And then at the April House meeting, we had a report from John Gross, which was hard. It was a very sober report about the revenue and expenses of the association over the next 10 years. And again, sort of looking at past 10 years, what was highlighted was, there were a lot expenses that needed to, be reduced because of the reduced in membership and revenue associated with that. So, these were hard decisions to make. These, but as I hear David talking about, how we all came together, and I think that's the strength of this association, is that we can do that working together. So most recently, when the MOU was signed, the Finance Committee met and started to really look at it, and what does this mean for the association? What are the fiscal implications to the association? And what we had long discussion. We had I'm sure we'll have more discussions, but essentially what we came to the realization is that we essentially needed more information. We needed more guidance from outside counsel, as David had mentioned. So what we've decided to do is we will be continuing our discussions with outside counsel related to those potential tax implications with a building transfer, as well as the Attorney General's approval. We'll also be looking at the joint fundraising activities and how can we structure fundraising to assure the support of the necessary fiscal implications of renovating a building, but also how do we work with this together with the foundation. And so after a lengthy discussion, we at this point I'm really just providing an informational report where we'll be continuing to give you information as we receive it, and as we're working with outside counsel, we'll be sure to provide additional information and report about how that turns out. So thank you.
Thank you, Sandra Rivera, for everything. I'd now like to move approval of the resolution that's in agenda item 6 that's been provided to all of you. There was a friendly amendment to this brought after we submitted it to you, and it's in the further resolved clause. That with the approval of the executive committee, the association president is authorized to enter into a final agreement regarding the property. So that was accepted. This is, of course, we're going to be, working very hard on making sure we get this right. And the executive committee will of course be there every step of the way. So I've made the motion.
Do I have a second?
Second.
Thank you. We now open it for discussion. I would ask any member who wishes to speak to please raise your hand so that we can take a look at the queue and make sure that we allot appropriate time so that the members who wish to speak can be heard. I would ask you to please keep your remarks to 3 minutes and follow the lights as they appear in front of me. The red light means your time is up. So I appreciate everybody's input. And I'm now going to call on our first speaker. Past President Justin Vigdor. Please unmute yourself and unvideo, or turn your video on, I should say. Past President Vigdor.
Thank you. Thank you, Madam Chair. I, as a past, I don't know if I can be heard or not. Can you hear me?
Okay. If you can hear us, we are calling on you to speak at this time.
Can you hear me?
Okay, we're gonna have to come back to Past President Vigdor. We will make sure that we get back to you.
Can you hear me?
Past President Sharon Stern Gersman.
Here's your paper.
Okay,
Oh.
it seems like we are having some technical difficulties, so bear with us a moment.
You're up bright and early.
So I've been on a
Sharon,
meeting.
are you there?
Oh, okay.
Okay. It appears that your mic is still muted.
Sorry, my mic
There we
is
go.
unmuted. Okay.
Yes, we can hear you now. Thank you.
First, I want to join in giving my thanks to the committee, Dave Miranda's committee, and all of the other committees that have worked so hard to make this a reality. And to maybe bring up one point that members of the House may not be aware of, and that is that the ownership of this building was with the foundation in part for tax purposes, in hopes that it would be tax exempt as owned by a 501c3. As has been reported in the past, that has not been the case over the last few years. There in fact is a lawsuit pending to turn that around, but no one is, I think, particularly hopeful that that's going to happen. And so with that advantage of having the foundation on the building diminished, it makes perfect sense to have the association own the building, pay for the renovations itself, and allow any accretion to the value of the property due to those renovations to come to the benefit of the association. I think this is a wonderful resolution of the problem. I'm happy to support the MOU and urge.
Thank you, Past President Gersman. I now see that Past President Justin Vigdor, I see your video is on. Are you?
Yes, can you hear me?
Yes, we can. Thank you. And sorry for the technical.
Thank you very much for affording me this opportunity. I simply wanted to, as a past president of both the association and the foundation, and someone who was very actively involved in the 1970s when the entire arrangement was formed and when the capital funds were raised for the building, I was terribly distressed when it seemed that we were veering towards a departure from 1 Elk Street. I'm delighted that that is now not the case, and that with the hard work of all the people that have been mentioned, we have this memorandum of understanding. It gives me great satisfaction to see this now occur and to permit us to remain in this historic and wonderful space. Thank you for permitting me to express these thoughts.
Thank you. I will next call on Mr. Richmond.
Thank you, Madam Chair. First, I also want to commend the committee. I think this is the ultimate result is in the best interest of all. But I'm concerned that in order to fulfill our fiduciary responsibilities, I would offer 2 modifications to the proposed resolution. First, in point 3, adding the words after the association, adding the words subject to available funding as set forth in the annual NYSBA adopted budget. The purpose of this is to ensure that, God forbid, we face another financial crisis. This House still has the right to determine each year where the best use of our limited resources are. Hopefully, over the life of this agreement, which is 15 years, as long as we have the building, this never comes up. But I think we need to protect our rights as a House member so that we're not paying the foundation's support before we take care of our association own needs. And secondly, with respect to the friendly amendment, I would add at the end, I still think to complete our final fiduciary obligation, that said final agreement shall be subject to ratification by the House of Delegates. I think that would make sure we could call a special meeting as we were going to call initially. It should take a few minutes if the agreement is in form, but then we perform our duties to protect the assets. And I think we'd be in a stronger position when we go to the Attorney General seeking approval. So I'd offer those first as friendly amendments. They're not accepted as friendly. I'd ask that they be considered as amendments to the resolution at the appropriate time. Thank you.
Mr. Richmond, I'd like to turn it to Dave Miranda to respond. Did you understand the first part?
Yeah, I mean,
Okay.
I'm going to say just right off the outset, neither are accepted as a friendly amendment. The first part, I think you're asking to change the memorandum of understanding. That cannot change. I mean, it's already been signed. That's if you don't agree with the memorandum of understanding, your option is to vote no. The memorandum of understanding to this issue, the decision on what we do to the House, that's what this is. If the House does not want to stay or does not want to stay under the circumstances outlined under the MOU, then I think leadership trusts the collective wisdom of this House. But we're not going to have the negotiation process hampered by having to bring it back to a House vote when the leadership wants to move forward on something that's already been approved by the House. So I do not accept that as a friendly amendment either. I think it's misguided and inappropriate for that. It hinders the ability of our elected leaders to lead us in the direction that the House wants us to go in. And of course, all of this will be, I mean, this is not the last time we're going to talk about it, I'm certain. So the House and the Executive Committee will be fully informed. So neither are accepted, and I would oppose both.
At this point, Mr. Richmond, I ask you to please raise for a motion, procedural motion at the appropriate time after the discussion is complete, if you intend to make one. Thank you.
Thank you.
Next in the queue is past President Tom Levin. Mr.
Yes. Good morning.
We hear you, and if you would mind turning your video on, we'd appreciate it.
Okay, it should be on now.
Yep.
Okay.
Thank you.
All right. First, good morning, everyone. I'm trying to be very brief. I certainly want to endorse all the comments that were made by past President Vigdor and past President Gerstmann. Particularly those that Justin made. I'm always pleased to follow Justin, who's one of my idols as a past president, and who I admire greatly. As many of you know, the past presidents have been involved in this process, starting on their own initiative for quite some time and very deeply. I think we have brought, I hope we brought to bear some collective wisdom on the problem and the eventual outcome. This became a very emotional issue in the association and the foundation. There's been a good deal of rancor, and I'm very pleased that the negotiating teams for both sides did what lawyers are supposed to do, which is to find a solution to a problem instead of harping on the problem and all its aspects. I think both negotiating teams deserve our thanks for all of the hard work they did to put this together. It will, of course, be up to all of us to make this work after the final terms are worked out, and we will all move forward together, I'm sure, to do that. I have one point I'd like to make. I'm not sure, Dave Miranda, maybe you can respond to this. This would be a friendly amendment if necessary. Has it been conclusively determined that no approval would also be needed from the court? Because the statutes on transfer of assets by not-for-profit corporations are somewhat complex. I've had a number of these matters that I've done myself, and most of the time the Attorney General approval is sufficient, but once in a while you need a court approval. And I'm wondering if it wouldn't be helpful just to add to that last paragraph at the end, and if necessary, the court.
So I can address that briefly. Past President Levin, I certainly appreciate your thoughts and comments. We've already incorporated one of your friendly amendments. I think that at this point, we are retaining counsel to look into all issues to make sure that it's legal. We have the provision specifically in the MOU that's it's contingent upon approval of the Attorney General. If there's any additional court approval, of course, we will get it. I don't think it's of benefit at this point to add it to the MOU. We're not going to engage in a contract of sale that is not in compliance with the law. I don't think we need to put that necessarily in the MOU or make any other further friendly amendments. But I assure you that outside counsel is going to be retained to make sure that we cross every T and dot every I and do everything properly.
Well, thank you. I'm definitely comfortable with that, and I certainly would assume we would do so. I was just concerned that I don't want anyone to raise a technicality later that the House resolution doesn't say that it's contingent on the court approval as well. Because obviously, if that is the law, that's the law, and we're going to follow it. So thank you. But I support this motion, this report.
Thank you.
Thank you, Past President Levin. Next, we have Past President Vincent Doyle.
Thank you, Madam Chair. Vincent Doyle, past president, and also full disclosure, I'm a new member of the board of directors of the foundation. And just briefly, I wanted to commend the leadership for hearing and listening and being responsive to the members of the House delegates and some of the past presidents, and to working hard on behalf of the association to reach what I think is an eminently reasonable and productive agreement. I think there's a lot of flexibility in this in terms of what the association can do with the building going forward. I agree with the comments, particularly past President Levin. This isn't going to be the end of it. We are all going to have to work very hard on the fundraising aspect of it. But for now, this is a very, very good resolution of a very difficult problem. And so I commend the leadership and I support the resolution in full. Thank you.
Thank you, Past President Doyle. I will next call on Michael Marinaccio.
Thank you. Thank you, Sherry. Can I be heard?
We can hear you, but we cannot see you.
That's a problem on my end.
Okay.
It's fine. You don't have to see me. I'd like to commend David and the committee as well. David, you're very persuasive, and you were also very persuasive earlier on in this process when you went over the numbers with us. As you know, I've commented in the past that I was troubled by some of these numbers. The One Elk has more space than we need, and I don't know how realistic it is for us to rent out space. I don't know if we really want to be a landlord. The cost to us of $800,000 a year, absent the rent that we were paying the foundation, is roughly equivalent to what it would cost us in any new space. But I am troubled and continue to be troubled by the need for upwards of $6 million in renovations for a building that I think was generously appraised at about $3.5 million. However, as long as we all understand that that $6 million is going to have to be spent sometime in the future, whether it's 3 years, 4 years, 5 years, and we know that going in, I think we all agree that One Elk is our home and should remain our home. So, David, you've convinced me to support this resolution. I don't know how much that might mean to you, but I'm not often easily convinced. We go into this with our eyes open. We have a big job ahead of us in these very lean times, but I commend you, the committee, and everybody involved in these negotiations. Great job.
Thank you, Michael. You were my target audience, so mission accomplished.
Thank you, Mr. Marinaccio. Next is past President Seymour James. At this point, we cannot hear oh, your video is on, but you're still on mute. If you'd unmute, please. There you are.
Thank you, Madam Chair. So I also want to thank the negotiating teams of both the association and the foundation for all the work they put in to come to this resolution. And I'm pleased that this resolution will result in the Bar Association remaining at its historic home. The Bar Center is ideally located near the Court of Appeals, the legislature, and the executive branches of state government. Any moving costs are always uncertain, and the long-term costs at a new location are equally uncertain. In the past, the foundation and the association have partnered to raise substantial funds for renovations and expansion. And I see this memorandum discusses the foundation and the association, again, partnering to engage in fundraising to support the historic home of our association. But not only would we be able to remain at our home, but continuing at 1L will give us, the association, the flexibility to utilize part of the building and to rent out or sublet other portions of the building, so that to reduce some of our costs. So I support approval of the memorandum of understanding and encourage other members of the House to vote in support. Thank you.
Thank you, past President Seymour James. Next, past President Vince Bizard. Okay, Mr. Bizard, if you could turn on your video as well as unmute yourself. If you could unmute yourself, we still can't hear you.
Can you hear me now?
Now we can. Welcome.
I hadn't said anything. Thank you very much, Madam Chair. I just wanted to briefly say on behalf of Steve Younger, of course, deeply regrets not being able to be here, but he asked me to express his thanks to the leadership for bringing this thing together. I know there were some times when we were like exchanging interrogatories, but it was all transparent, all well done. I think I personally spent a lot of time wasting Dave Miranda's time, and I particularly want to thank him and the other leaders. But because Steve was our leader of the past presidents, I thought it was important that his gratitude for this outcome be expressed. Thank you.
Thank you, Mr. Bizard. Next. Next is Yamika Stevenson. Am I saying the name correctly? Because I don't see your name. I'm being told your name's.
Yeah, the name actually didn't go through, but I'm also with council section, Kenneth Zweig.
Oh, Kenneth Zweig. Okay, I apologize. Okay.
For some reason it came up under Yamika's name.
Okay.
My question was regarding the outside counsel that we're going to use. What firm? What is the process like, and will it only be related to the tax implications, or will it also be related to the underlying transfer of ownership?
Yeah, so it looks, I mean, at the moment, we've got the Finance Committee looking at this, but at the moment, it looks like we're going to have two outside counsel. One to address the issue of approval with the New York State Attorney General because of the 501c3 status of the foundation. And the second to look at the tax implications and make sure that the final deal is structured in a way that is both legal and beneficial to both organizations. If in the investigation it appears as though there's another issue that we need expertise on, I think the expectation would be that we would make sure that we do everything we do to make sure we do this right. But right now, the expectation is that there would be two outside counsel retained for those two issues.
Thank you. Okay. If I now call on past President, immediate past President Scott Carson, who I'd like to also thank for all of his efforts in working through this issue.
Thank you, Madam Chair, and good morning, everybody. As someone who has been referred to as hardworking and deserving of thanks, and by others in terms not quite so flattering, I simply want to indicate that I think that this is a great result. It resolves, hopefully, what was a very divisive issue that would have probably caused long-term harm and discord within the New York State Bar Association and the New York Bar Foundation. And as you've heard so many times already this morning, this was the result of some amazing hard work. And when I sent a letter to my counterpart in the foundation back in the fall of last year, I had no idea that it would result in this kind of procedure and process, but one which I think has resulted so well. So I join in thanking the leadership of the foundation in joining us in this memorandum of understanding, which I was pleased and proud to have signed on behalf of the association. And I will tell you that I am prepared to proudly cast my vote in favor of the resolution this morning, because I believe it's not perfect, and as with all things, as Tom Levin indicated, that where lawyers are involved and the process of negotiation takes place, there is give and take. And while I think that perhaps neither side was fully on board with each and every element of the memorandum of understanding, I think that on balance, we all win by ensuring its passage and adoption. And finally, I join with all the thanks that have been given to the folks on our side who I so proudly worked with, and in particular, President T. Andrew Brown and the members of the Finance Committee, led initially by John Gross and then by Michael Miller, and now by Sandra Rivera. And of course, it goes without saying, the tremendous work put in by our lease negotiating team, led by this fellow standing here next to me, Dave Miranda, former president, who did such an outstanding job. And I'm sure he'll never forgive me for asking him to take that job, but I think that my instincts were good, and that I think we were by David's leadership, and he was joined, of course, by Sandra, who's sitting to my other side, and Michael McNamara, who formed our lease negotiating team. And as a result of the hard work and persistence by all of those people, we have something that we can all be very proud of, and that will enable us to move ahead in peace and harmony at 1 Elk Street. And I thank you all.
Thank you, Mr. Carson. Other hands in the queue? At this time, I will ask if there are any procedural motions. Seeing no hands raised. 2.
Call the question.
Okay.
Call the question.
Call the question. Okay, at this time, we're going to call we will now take a vote. The poll window with voting options will be displayed within the Zoom window on your screen. Please select aye, nay, or abstain. And if you abstain, please remember to email Kim McCarg at the State Bar, and then submit your vote. Abstentions will be recorded in the minutes. A poll will remain open for 30 seconds. Yeah, record. 1, 2, 3. I voted online.
I voted online.
Oh, wow. Motion passes. The motion passes. Thank you, everybody, for your good work. At this time, I am happy to say that we have worked a short break into the meeting. We will take a 5-minute break. It is now 9:58 of my reading of the screen in front of me. We'll make it 7 minutes. Come back at 10:05, please, to continue. Thank you.
Much as I like having my picture up, can somebody take it down?
Test, test, test.
Welcome back, everybody. Please let us know if for some reason you cannot hear us. At this time, we're going to continue with the meeting. But I'm going to take a moment and a point of privilege as the chair to recognize our immediate past president, Scott Carson, who is going to give a brief memorial for the passing of Judge Robert Katzman, Chief Judge of the Second Circuit.
Thank you, Madam Chair, and good morning, fellow delegates. This week, we received the sad news of the passing of the former Chief Judge of the United States Court of Appeals for the Second Circuit, Robert Katzman. And I will speak just very briefly this morning in his memory. Judge Katzman was a distinguished jurist and leader of a great court. He was respected throughout the nation, but particularly here in the Second Circuit. And while I never had the opportunity to litigate a case before Judge Katzman, I will always remember him because of his devotion to a key part of our mission here at the New York State Bar Association, which was the promotion of civics education. As some of you will recall, last year, during my presidency, we were hard at work on putting together a convocation on civic education. Unfortunately, the pandemic intervened and we had to cancel that. And it's my hope that someday we shall do it again. But one of the privileges I had in leading up to that, the planning of that event, was to attend a convocation run by Bob Katzman at the Second Circuit Court of Appeals, where jurists and court personnel from all over the nation joined to discuss ways in which the courts and the schools can partner in promoting civic education. And in fact, the Second Circuit Courthouse is well known for its civic education facility, which was the work of Bob Katzman. So at this time, I simply want to share with you the sad news of his passing and to ask that we observe a moment of silence in his memory. I thank you very much for your time, and I hope you enjoy the rest of the meeting. Thanks.
Thank you, Past President Carson. We now continue with the agenda of the meeting. The next report on our agenda is the Task Force on Racial Injustice and Police Reform. The task force was appointed to examine the issues contributing to police brutality and to provide recommendations to policymakers, elected officials, members of law enforcement, and the judiciary to end harmful policing practices that disproportionately impact persons of color. The report will be presented by our President, T. Andrew Brown, and our Secretary, Taya Grays, co-chairs of the task force. At its meeting yesterday, the Executive Committee endorsed the report and recommendations of the task force.
Thank you, Madam Chair, and I'm pleased to present the Racial Injustice and Police Reform Task Force report and recommendations, along with my colleague, Taya Grays, who is sitting next to me. In my presidential remarks, I spoke about twin crises over the past year. Those twin crises were the COVID-19 pandemic and the issue of social justice arising in law enforcement following the killing of George Floyd. As was just mentioned, this task force was created by past President Scott Carson. The task force mission, in short, was to address issues of racial injustice and the need for police reform. We have before you a report with recommendations. This is a report of some 120 2 pages, I believe. So obviously, we're going to speak in a brief and overview fashion. The recommendations are to support legislation and other policy changes and initiatives that we've seen over the past year. Ever since the killing of George Floyd, we began hearing about this issue on a daily basis. This is not a new problem, sadly. George Floyd did not surprise many in the Black community. It is something that has been talked about for as long as I've been alive, for as long as there have been policing in America. There was video of this incident. It caused a level of outrage and a call to action. So the question can be raised, why are we preparing the report and looking at this now if this is not a new issue? There's never been a time like this before, quite frankly. This is an opportunity to seize upon an issue and be called into action. Every day since the killing of George Floyd, we have seen the issue on the front pages of newspapers and on our TVs. Lawyers have an inside look at this issue, and we have to do what we can to help resolve some of the problems. We have to also remain relevant and responsive to members who are looking at this and to the public at large, quite frankly. Injustice anywhere affects us all. And I want to say at the outset before we continue, this is not a problem with policing. It's a problem with bad policing. We salute the men and women who go out every day and do the good work of policing, safeguarding our communities. This is an issue with bad policing, and we as an association have to do what we can to help address it.
So to that end, Andrew and I are going to discuss the recommendations in the following ways. So first, Andrew will talk about what 21st century policing means. He's already given you a bit of a preview, but he's going to drill down a little bit more into what that means, because that's the frame for our recommendations. Following that, I will talk about the stages of policing that Andrew also made reference to, and where are those key points where our recommendations fit in. Then finally, we'll have Andrew again talk about additional accountability within the criminal justice system, discussing the other batches of our recommendations. As you can see, these are the 2 organizing principles. The larger frame is the 21st century policing, under which we have these 2 buckets. We will then give some thank yous to those who have helped us prepare this report, and then we'll take questions. Back to you, Andrew.
Thank you, Taya. Just briefly, when we talk about 21st century policing, we're really talking about bringing policing into the modern age. We're talking about making policing responsive to communities. We're talking about making policing responsive to the communities and the people that they serve. And we're talking about making policing part of communities, as opposed to policing agencies being some type of militaristic entity that functions outside of communities. And we've seen that much too much over the past years and for far too long. That is something that has not worked in our country. It's never worked. And we need to change that. And those who are looking at policing and talk about 21st century policing are looking in those ways. One of the things we have to do is we have to align police professionals to other professions. We have to make it such that people want to go into the profession and the right people want to go into the profession. We have to look for ways of elevating the profession, elevating standards and respect. We have to look at how we can make this as a profession similar to other professions to earn that level of respect. And we're going to talk a little bit about that shortly. But the fact is, you can become a police officer with far less time and training than you can become than is necessary to become a cosmetologist or a massage therapist. We also want to look at, again, making the community the center point. That's essential for good policing as we've examined it around the country. We'll talk a little bit more about that. We also have to look at modifying criminal law procedures that hinder police and hold police officers accountable for misconduct, as well as increasing diversity and diversity training. That's essential. Those are components that are necessary in any sound policing plan. We also have to look at taking advantage of modern day technologies that weren't available at times in the past. We want to use that technology to obtain data. Courts can do that more easily now than ever. That will serve us well as we look forward and create better policing agencies in an attempt to rid those agencies of racial injustice and bias targeting. We also want to look at use of cameras, unlike we've done before. Cameras should be, we believe, worn by every police officer in the field and also mounted to every car, patrol car. That is something that has been done in many communities. We believe it should be more widespread. Much of what we're talking about is embraced in legislative reform, or looking at it another way, these recommendations that we are bringing forth will serve to support the effort of legislative reform and the need for police reform. There's no silver bullet. You'll hear us say that time and time again. These are recommendations that will support some of what we've seen done. And we've seen a lot done since the killing of George Floyd. We've seen efforts of reform here in New York State and literally in every state across the country.
So now let's proceed to the first organizing principle, which is around improving policing at key stages. Apologize, we have to make sure we get the mic set up. So what I'm going to do is just talk about the first, what are the cycles, what are the key aspects of the stages of policing? So first there's hiring, there's training, there's being on the job, there's monitoring, and then there's disciplining. Our recommendations fit into these particular areas in the following ways. So our first bucket is around what are the requirements for someone who wants to be a police officer? And we've identified 3 different things that should be added to those hiring requirements. The fourth area is around what the police department should be doing in order to increase the hiring of those who are diverse. The next bucket is around training. So once you get someone in the door and you get them with the right qualifications, then how do we make sure that they are successful in the role? And so we have 2 different areas around training that police officers would have during the course of their duration as a police officer. In addition, more specific training as it relates to individuals with disabilities. Police officers don't receive sufficient training in that area, and we know from the statistics that at least 23% of those that are unfortunately at the hands of police misconduct and excessive use of force are those with disabilities. Then when they're on the job, 2 key things. 1, a duty to intervene. Police officers would like to intervene, but they have cited in some of the research that we've seen that there isn't accountability within their police departments if they do stand up if someone does something inappropriate. So put in place a legal obligation to do so. And then the second piece, which we'll talk about a little bit later, well, Andrew will talk about, is civilian oversight. This key piece is making sure that policing practices that the community sees are brought back to the police departments, and it can be used to enhance how they engage with the community. Next, we talked about technology, and that's the body cams. My clicker is just not advancing. And so what you will see when it does advance is that we're looking at leveraging the technology that Andrew had made reference to. And then lastly, as it relates to disciplining, making sure that other departments have access to records for police, good or bad, as they go to other employers. And then now I will segue to Andrew, who'll talk about strengthening our community oversight role. Andrew?
Thank you, Taya. Again, realizing that we're not able to go into great depth here today, we're presenting everything in an overview fashion, but Taya certainly could have spoken at far greater depth and length on the issues he just covered. One of the important changes that we think is necessary is with respect to community. And keep in mind that 21st century policing has a bigger role for the community to play, and communities have to be at the center. Many of you are familiar with Executive Order 203 that was issued by the governor over the past year that required every municipality to engage in a process to review their policing agencies and to devise a plan that would better serve the communities, including those most vulnerable, which are Blacks and other people of color. And we believe that one of the key ways of doing that is to empower civilian oversight boards, not simply review boards, but oversight boards. And there's a difference. Many of the past community oversight bodies were review boards, simply reviewing processes and making recommendations. And we see that that has not worked. It has not served us here in New York State or in any other state in the country. We did do a program not too long ago, back in January, featuring civilian review boards and oversight boards. And one of the things that came out of that was that there's not one civilian oversight board in the state that has been successful in New York. So we have to empower these bodies to do more and to also be able to assert discipline over policing agencies. We can certainly talk more about that, or you can certainly read more about it in the reports if you haven't already. With respect to the attorneys in the process, we believe that there should be greater implicit bias training for all of those attorneys involved in the system, whether it be prosecutors, defense counsel, public defenders, attorneys in the AG's office. We believe that that can go a long way, as well as advancing diversity and inclusion efforts in those offices. With respect to courts, we believe there's also work to be done there. We believe that there should be more fostering of diversity in recruitment, hiring, promotion, and retention. We also believe that courts can do more to collect demographic data. In the past, it's often been very difficult to get information from the courts with respect to how different peoples are being impacted, and with respect to arraignments and sentencing. And we know that Blacks have suffered in that regard, and they have gotten less favorable pleas, greater sentences, and we see more wrongful convictions in people of color. We also believe there has to be implicit bias training for jurors, which we don't see taking place now. And lastly, I'll just touch upon the criminal justice system. We have to seek change there as well. For instance, we need more controls and guidelines for gang databases. Those are collections of information on people that policing agencies often use without public oversight or public awareness at all. We see in New York that many of those databases are made up of almost exclusively people of color. It was testified in 2019 that 99% of the people in New York City's such databases were people of color. That's a problem. We also know that there's a need to reform qualified immunity. Qualified immunity has been used by many policing agencies and officers to shield bad policing practices. It is commonly used for defense in cases brought against officers. And we talk about the need to reform that. We believe that that would give individuals who suffered at the hands of bad policing an opportunity to go into court and seek rectification of the deprivations. And lastly, I will mention the need to review the influence of police unions. We have seen that many police unions, in strong advocacy for their officers and their members, not unlike other unions, have carried out their work in such a way to shield much of the misconduct that we have seen over the years. And the effort of police unions to combat any changes in reform has gone a long way in preventing agencies and communities in the state of New York from bringing about meaningful reform.
And so I know we are short for time, so we will quickly go through this next slide and then do our thank yous. So first, this is the next step in the evolution of policing. This is one of the reasons why we want you to adopt these sets of recommendations. Every few decades, there's a look at what police are doing and responding and making changes in order for them to adapt and be successful. Next, our recommendations are evidence-driven. As you can see, we had hundreds of interviews. We had 5 different committees that did this work, 4 public forums, much research on various reports, books, and other documents in these key topics. So we drew on that experience, our own judgment, to put forth these recommendations. And as Andrew said, there isn't a silver bullet to eliminate racial injustice in policing practices. That's why there are 23 different recommendations, because the issue is in different places in the system, and you need to have specific recommendations and specific solutions for those areas. Next, these recommendations support and supplement recently passed legislative reforms. If you look at our report, there are various other jurisdictions and within New York State itself that have passed these types of reforms. And so we're building on that. Next, these recommendations dovetail with Executive Order 203 plans submitted by various police departments. The committees, Andrew and myself, we looked at those and we made sure to incorporate those things that we thought were consistent with our overarching frame of 21st century policing. And then last but not least, to end on the note where we started, this is advancing New York into 21st century policing. We have methods that were effective last century. They're no longer effective. They are allowing the continued racial injustice in our system and policing. We want the good police to be able to do their jobs. We want the bad police to not be able to do their jobs. And so now, very quickly, these are the members of our task force. As you can see, a very diverse group of individuals from various backgrounds with various subject matter expertise. The committees, these are the folks that were the engine to make sure we got the work done. Thank you all for their work. And the staff, we could not do this work without the staff. Key members are listed here. And so now I turn it over to Andrew to do the Q&A jointly with me.
So may I have a motion to approve the task force report and recommendations?
So moved.
Second.
There's been a motion and a second. We now move to discussion. Anybody who would like to be heard on this issue, please raise your hand and we will call on you. Kenneth Zweig, please unmute yourself and turn on your video.
Good morning, and thanks for the task force for putting together such a comprehensive plan. And I really applaud the task force for doing that. I think it's important that we still have this issue brought up. Can you hear me?
Kenneth, if you don't mind starting again, because we missed the beginning of what you were saying, at least here in this room, and start with identifying your affiliation. Thank you.
Kenneth Zweig, I'm with the Corporate Counsel section, House of Delegates. I just want to applaud the task force for putting this together and keeping this on the front burner. I think it is an important issue, and I applaud the task force for their comprehensive evaluation. And I think one of the other things that really need to be added is the fact, and I think Governor Cuomo probably brought this up years ago, was that each county has a sheriff's office, each municipality has a police department, and there's just too many police departments, I think, within the state of New York. I think diversity is an issue for county police departments, but for municipalities, not as much. So I think the task force also needs to identify if it's necessary for each county, and I'm sure it'll touch on a hotbed issue, but for each county to have a sheriff's department. And I think that's something that could be added to the task force to look at.
Ken, thanks for your question. I don't disagree with you on that point, but I think the same thing could be said about fire departments and many other departments of cities and towns across the state. That is something that would have been beyond our mission, but it is certainly something that we will consider if we have the opportunity to discuss agencies, especially in those communities that are made up of many smaller villages or towns that have separate policing agencies.
Thank you. I will next call on Steve Richmond.
Andrew, very good report, both of you guys, but quick question, just in terms of coverage. You specifically refer to state troopers, but is the intent of the report to cover all of the state law enforcement agencies, NCON, SUNY, Parks, the uniform court officers? Are they all there? Is it just a question of not clearly defining them, but should all of them be covered as well?
In our executive summary, we are only focusing on law enforcement. So it's police departments, it's like NYPD in the big municipalities, as well as the sheriff's offices. We didn't look further into the other areas like court officers, although there's one recommendation as it relates to training in the courts where the court officers would be incorporated into that. But this is really looking at sworn officers as defined by the Division of Criminal Justice, those that are allowed to carry weapons and use lethal force. Andrew, do you want to add?
It's Stephen, that's the point. Like NCON has those police. If you go to the state park police is there. That's what I'm wondering, do they covering the state agencies as well as the court officers, which are state police officers under the CPL?
Yeah, Steve, I think to augment what Tay just said, we're actually trying to extend much of what we're talking about to as many police officers as possible, and to as many people who would refer to themselves as police officers, people who are in position to carry weapons and people who are in position to make arrests. All of those types of officers, men and women, would be within our sights to the extent possible. But as you know, many of the laws that are in place only respect to certain segments. For instance, one of the things that the governor did in one of his reform initiatives is to amend the laws against state police officers or state police. They all have to wear cameras, but that did not extend to many of the men and women on forces in the various towns and communities across the state outside of the state police ranks.
Thank you. Next, I see David Cohen.
Thank you, Madam Chair. I rise in support of the motion. I am the chair of the Criminal Justice Section. I'm a member of the Executive Committee, but I rise to speak as a member of one of the committees of this task force, that being the Prosecution and Court Reform Committee that was ably chaired by Clotel Drakeford and Nigel Fahrenheit, as pointed out. First of all, to the chairs of the task force, both Mr. President and Madam Secretary, you did a masterful job in shepherding us through this work and providing us with guidance and input. I'm also very appreciative of the fact that the report of our committee was carefully reviewed by you, and you adopted many of the recommendations that we made after discussion, especially those that relate to implicit bias training, both in the employees of the court system and significantly in prospective jury instructions that are given in both civil and criminal cases. Implicit bias training is imperative, especially in the court system, which has had a long history of implicit bias against people of color and people of underserved communities. So it's extremely important that this association take the position as set forth in the report that implicit bias training at all levels of the court system, starting with the judges, down through the court clerks, down through the court officers, through the lawyers, and all other participants received this important instruction. So I commend you for this report. I appreciate all the work that you did, and I urge the House to adopt the report. Thank you.
Thank you.
Thank you, Mr. Cohen. I now recognize Paula Engel. Okay. Ms. Engel has taken her hand down. Vivian Wessam. You can turn on your video.
Camera should be on now. Good morning. Thank you so much, Madam Chair. My name is Vivian Wesson. I chair the Committee on Attorney Professionalism. I thank President Brown as well as all the other members who helped write and research this report. But I do have a particular concern about the college degree requirement, and two parts to my question. First, that is the state prepared to allocate the necessary funding that's going to be required to recruit these new elevated professionals? Requiring a degree certainly will also perhaps impact your ability to recruit. The pool will just simply get smaller. And the other part of the question is, you consider requiring a specific type of degree. Surely we're not talking about a 2-degree associates in basket weaving. It should be something that is germane and relevant to actual possibly policing, maybe psychology, sociology, something that really deals with the field of some of the things that police officers are going to actually encounter out in the actual field. So I was wondering if you could speak a little more to the college degree requirement and what your thoughts were in research on that.
Vivian, yeah, we can say a little bit more on that, realizing that we are constrained for time. But a couple of things I do want to point out, and that is this: in the United States, more than 50% of all officers have 2-year degrees now, and more than 30% have 4-year degrees. The city of New York, our largest policing agency, every officer has to have 60 credits, which is the equivalent of an associate's degree, or they can waive that if they have military experience in their background. We did look at research and data, reliable evidence that does show that having a college education does help. It reduces use of force, and when there is use of force, it lowers the level of force used, and actually goes a long way at reducing misconduct by police officers. So we didn't really look, and when we look at other countries, college training is a requirement for many of the leading nations. And we also see that when we look at other countries, that most leading countries require more in the way of training. To become an officer in New York, you only need 700 hours of training. That's less than it takes to become a cosmetologist or a massage therapist. We believe that has to increase along with the need to have a college education. We have not looked at particularly the types of study that would be necessary, and we would assume that would be something that would be discussed at some later point if it became mandatory that all officers have to have college education. But I do believe that a broad-based education would probably serve most men and women best that are looking to become police officers.
May I just add one thing? To the point that you raised about the funding, we know that college education generally, we know is becoming more expensive. I think that's probably part of why you're asking the question. But if someone is interested in becoming a police officer, just like if you're interested in becoming a lawyer, if you're interested in becoming a doctor, that's the investment that you make in yourself. Now, we can further look at, are there ways that we can provide some either funding or some other incentives for individuals to take on getting a college degree in order to become a police officer. But I would say if someone is interested in this type of work and the type of people that we're looking to recruit, it's an investment for them to make in themselves. If they're looking to advance or they need some additional incentives around that, we can talk about that as a later thing to address that issue.
Yeah, you certainly should be looking at this as an investment also in their community.
Now, I'm sorry,
Thank
Ms.
you.
West. I
No
apologize.
problem.
We're now going to move on to Mr. Effman, Norman Effman.
Thank you.
You're muted and your video's off.
I should be visible
You're
now.
coming through
and heard.
now.
Okay. Thank you, Madam Chair. First of all, I'm sorry. I'm an elected delegate 8th Judicial District, former Vice President of the 8th. I'd like to compliment the work of this task force. It's unbelievable. I read it till about midnight last night, and there's about 1,000 pages of material to read for this meeting. And while you focus mostly in your presentation on police conduct, your report, of course, also deals with the bias issue that David Cohn spoke about earlier. And I really want to amplify that part of the report, and maybe even suggest that as we go on these issues, that another task force or this task force continue on really examining the post-arrest situation, and that is the trial itself and bias impacting jury selection and the makeup of our juries throughout the state. You've mentioned a lot of it in the report, including expansion of voir dire. We have come around in this state through the culture of the day to appear in a criminal trial and be told that you have 15 minutes on the first round to examine the 21 jurors in the box, and 15 minutes in the second round, given a minute or a minute and a half apiece to go through a voir dire. And if you're dealing with a situation where potential bias is an issue, that is certainly not enough. And lawyers in both sides of the fence are not really trained, that I can see, to really go through a voir dire the way it was done, let's say 20 years ago, rather than in the new culture of limiting voir dire and having the judges take over more and more of the voir dire process, not unlike what occurs in the federal system. So we really should be looking at expanding the voir dire. There's a movement to eliminate preemptory challenges that's not making much headway in New York State, but we should make sure it doesn't make any headway, because the ability in a racial or ethnic situation involving a potential client really needs to have a thorough voir dire examination and not the elimination of preempts. And then the other aspect of this is our use of the Batson rule with respect to the use of preempts and an attempt to stop bias on either side from eliminating certain jurors. There's a movement across the country, and New York is one of the states that's looking at it as to whether Batson really works. And for those of you who don't practice in this venue, Batson's a difficult situation. It's like a three-stage test. The first thing being to establish that the one side or the other is using some sort of pattern of eliminating particular jurors. There are statutes and states that are experimenting with something other than Batson. The best example is probably Washington State, which reverses the whole situation where you don't have to establish a pattern. If it's apparent that there's a potential racial bias involved in an elimination of a juror, it becomes the burden of the individual using that preempt to establish that it was not racially biased. And I think we should be taking a look at how we can get more diversified jurors. King County, which is basically Seattle and Washington State, when it went to a modified rule under Batson using this reverse kind of situation, had far more diverse jury panels, and as a result, far more hung juries, something that you might expect. So sorry, my time is up?
Yes.
Okay,
Andrew wants
I
to answer
can't
the
see the
question.
red light. It's a real small screen. So I'm just going to say, I would ask this committee to think about going forward with eliminating bias in the courtroom. And just a quick note, I know that the court system is producing a video and instructions on racial bias for juries in New York State, and that will happen very, very soon. Thank you.
Thank you, Norm. All your points are good ones. I know that you have spent many years in the trenches of the courtrooms, and so you know of which you speak. We did look at issues of the need for implicit bias training with respect to the courts, the attorneys, and juries. We also looked at some issues around jury selection and need to expand voir dire. Some aspects of what we looked at is really just a way of teeing up some of the issues. And I would submit that much of the good in our report is not so much in the recommendations, although the recommendations are important, but in the discussion. The underlying discussion is where the real meat is. And I would certainly encourage all of you to go back and look at the discussions. And Norm, as far as looking at some other issues, we will certainly consider ways that we, as a bar association, can continue to address some of these important issues that you raised. So thank you.
Thank you. I'm just going to let the members know that we have 6 minutes left allotted to this time, to this report. The next person who I'm going to call upon is Ms. Paula Engel, who I believe has come back into the queue. Okay, apparently she left again. I see the next person is Myrna Santiago. Good morning.
Hello, thank you so much. I just want to start off by saying congratulations to Secretary Taya Graves and President Andrew Brown for putting together this report. It was a little bit like herding cats, I know, because of all the committees and all the information and the sources that all of the committees put into their reports. And this task force report is just amazing. Thank you so much. It was really great to read, even being a member of the task force and co-leading with Asha Smith, the legislation committee part of the task force. With that said, I want to respond to one of the comments that were made earlier about the fact that the pool will get smaller if we increase or if we recommend the increase of qualifications for police officers. I think it requires a change in mindset about who police officers are and people in law enforcement are and what they're designed to do. They literally hold people's lives in their hands. And I don't believe that we can treat them as line essential workers, as people who, because we want a bigger pool of people who may or may not be qualified to do that kind of work, that we keep the qualifications low. I agree with all of the recommendations, especially about education. The studies have been done, empirical studies do show that people with a higher degree of education, especially in a formalized education setting, like a college, have not less implicit biases, but ways to work through some of the biases that may come up as they do the work. And I think that's important. I think it's important that our police officers be treated as professionals. And I think that we may lessen the pool of a certain type of police officer, but we will actually widen the pool for different types of people who will no longer be seeing police work as lower level types of essential work. And I agree again with all of the recommendations in the report, but particularly with that one. And I don't think that that's something that is a negative. It's actually a positive and will bring us in line with a lot of the European countries who require not just a higher education for their police officers, but also more on the job training, where we have less than 6 months of training for our police officers. Certain of the European countries have years. So again, I commend you both on putting together the report, and I look forward to seeing some of these recommendations implemented. Thank you.
Thank you, Ms. Santiago. I see that the Paula Engel we were trying to get is actually Jessica Parker. I recognize you. Please keep your comments as short as possible. We're running out of time on this report. Thank you.
No, thanks for the recognition. I actually just had one question. I do know that, lawyers were very much involved in the day-to-day of what goes on in the courts and with the police. But have we thought about partnering with the police forces, and talking to them? Because as many of you know, I'm married to a retired federal law enforcement officer. And so I've had an opportunity to speak with many of them, and they are almost more angry when a bad cop does something than the public is. And they might, just like we, for lack of a better word, police our own folks through our attorney discipline rules, I think the police might have a very good idea as to how to better educate the bad eggs in the police force and to deal with them. And I just think it makes sense to try to include them in the discussions.
Jessica, if I can speak to that, I think you're 100% correct. And I will note that our task force included former police officers, including one officer, Robert Brown, who was a former captain on the New York City Police Department for more than 2 decades. We also had other former police officers on our task force. I also note that I personally have represented police officers and policing departments across New York State and state courts and in federal courts, and have gone to verdict representing officers. So I certainly understand the viewpoint of police officers, and we'll continue to work with police officers because I think that's essential. One of the things that the governor required in his 203 plans was for policing agencies to work directly with communities, all stakeholders in the community, to devise more essential and responsive policing plans.
And can I add very quickly to that? We had 4 public forums, and at 2 of those public forums, we had senior level police officers, people in leadership who came and spoke to us. And so we've established relationships with them. And then I'll also add, I'm a former prosecutor. And so I've worked also a lot with police officers as well. So Andrea and I bring a perspective of understanding that there are good police officers as well as there being bad police officers. And as part of being a prosecutor, I used to prosecute those cops who were bad. And so I understand both sides of the issues, and that's part of the experience that we brought to this and bringing in the right people in order to develop the report. But thank you for pointing that out, Jessica, because we do need to work together with the police in order for this to be successful.
Thank you. Okay, we have one more comment from Drew Jagman. Sorry, Drew.
That's all right, Sherry. Drew Jaglam, I'm a delegate from the business law section and just completed a term on the executive committee, but I'm speaking only for myself. I just want to comment. It's a terrific report, and Andrew and Taya, thank you for your leadership in getting it all pulled together so magnificently. I just want to comment on Myrna and Vivian's comments regarding the college degree requirement, which I think may be a double-edged sword and needs some consideration. And my view, like Jessica's, is colored by my spouse. My wife recently retired as an inner city school teacher, where she coached the law team and brought a lot of kids to the point of being able to get into colleges. But a significant number of them really struggled because of the lack of preparation that they had in their early lives to succeed in college. And I'm thinking of one in particular who is a rising star public official, but was not able to get a college degree. And I just wonder whether we are going to be excluding from police forces some of the people from the communities that should most be represented if we impose a requirement that their disadvantages keep them from meeting. I'm all for expanding police training, perhaps adopting the European model of some years of training. But I wonder whether an academic college degree that our society has made a challenge for people in poorer communities who are unfortunately also usually people of color are going to have difficulty meeting. And I think we may, by doing that, be excluding from police forces some of the people who we most need there.
Drew, thank you for that point. And as you know, and many of you know, I spent many years on the Board of Regents setting educational policy for the state of New York at the highest level. We certainly don't want to do anything to discourage people of color from going into the profession of policing. We want to encourage that. Again, I point out that in the city of New York, which I believe most police officers now are people of color. And in New York City, there is a requirement that any new officer have at least 60 credits, an associate's degree equivalent, to come on to the force. So I believe that we can certainly look for ways to encourage people of color going into policing and then supporting them to the extent that we have to with respect to the finances needed to make that a reality. But I think we have to be mindful that this is a benefit. We've seen it, the data backs that up. So we'll simply have to address the issue of access when the time comes, if there is in fact statewide legislation.
Can I just say one other thing to that? I mean, Drew, you're raising a great point, and it's something that not only affects police, it affects everything, right? That these educational issues impact people of color being able to go into many different professions, which means it's a much broader issue than what we can deal with here. And I think there are probably other task force and there's some other places where that issue needs to be dealt with. But the fact remains there are definitely benefits to police officers being better educated and dealing with the type of social issues and the complexity of the communities that they have to police.
Thank you, everyone, for this discussion. I'm now going to ask for a vote on the motion that's on the floor. The poll window with voting options will display within the Zoom window on your screen. Please select aye, nay, or abstain, and then submit your vote. The poll will remain open for 30 seconds. Thank you all. The motion carries. Thank you for your report. The motion is adopted, or the report and recommendations are adopted. We now move on to our next item on the agenda. This is the report on the task force on free expression in the digital age. The task force was appointed in 2019 to study the crisis in local journalism. You may recall that the task force presented its original report in April 2020, but that report was tabled to permit additional time to address concerns that had been raised, and the report has been significantly amended. The report will be presented by the task force co-chairs, Cynthia Arado and David McCraw. Welcome and thank you.
Thank you. I want to make sure everyone can hear me.
Yes, we can hear you.
Great, thank you. Thank you for the opportunity to present this report and to do such important work for the Bar Association. We've really enjoyed our experience. Our report and our whole task force stems from what we identified as an existential economic crisis in local journalism that had been unfolding over the past years, and which we felt, and I think other people recognize, is essential to the full functioning of a robust democracy. The change was brought about by economic forces, by changes in advertising and digital media, and those we recognize are problems that can't be cured by the law. But we found that the legal community has a vital role to play in ensuring the survival of local journalism, and that we could propose recommendations that could support that vital organization. So our report calls for measures designed to reduce the burdens faced by local news organizations in getting information, in helping citizens get access to government information at a time when there are fewer and fewer journalists and institutions available to provide basic local reporting, and to encourage the expansion of nonprofit news organizations, and to foster a broader provision of legal services to journalists and to news organizations on a pro bono or low cost basis. Our report, as you noted, has been modified from its original form, but we continue to propose that the bar support expanded pro bono legal services for news organizations, especially nonprofit news organizations, which are flourishing now and a growing force in the journalistic field. Many of those new organizations are run by women and journalists of color, and they bring new voices to the public forum, and we think it's important to support them. We also propose further study of public support of news organizations, including models that we've seen for public radio and public TV. With respect to our process, our task force was comprised of members with a broad cross-section of perspectives and experience. We have former and current judges. We have attorneys who deal in FOIL requests and who represented agencies in responding to those requests. We also held a number of open meetings, which was essentially a listening tour, which included forums around the state, in person around the state pre-COVID, to investigate and discuss the topics we address, and during which we spoke with current FOIL officers. Although we had not been approached by the local and state government law section after our report was tabled and first presented last year, we actually reached out to the section so we could hear its views. We had a very productive, lengthy call with representatives of that section a few months ago, and we modified a number of our recommendations to accommodate concerns raised by that section, and we're thankful for their participation in this process. To date, 2 committees have submitted statements in support of our recommendations. The Committee on Legal Aid and the President's Committee on Access in Justice support the task force report, finding that the recommendations are vital to equal access to justice in terms of encouraging the more free flow of information. The local and state government law section has objected to various recommendations regarding FOIL and proactive government transparency, and David's going to address those subjects.
Thank you, Cynthia, and thank you, President Brown and delegates, for hearing us out this morning. It's early here in California, so if I stumble, that's the reason. So I want to address some of the concerns that people have raised, because our reports before you, you know, the proposals that we've made. It's really focused on, is there anything we can do about the delay that requesters face in getting responses to FOIL requests? Can we set some timeframes so that when public meetings are being held, citizens and journalists have that information in a timely fashion? And can we make sure that basic government documents are available routinely to journalists and to citizens? We've been hearing a lot about equal access to justice. We think this is a piece of it, that this is an important part of how transparency helps make sure that people get a fair shake in society. It's by knowing what government is up to. And I think that's been one of the lessons we've seen over the last year. So when we become aware of problems, we can deal with them. When problems are hidden, we don't. I understand, and as Cynthia said, we met with the leadership of the local and state government section, and it was a very productive meeting. What was interesting was that several of the attorneys on that call from the government side also make FOIL requests. Nobody said it's working great, no matter whether they were which side, whether they're on the requester side or they're the government side. They make an important point in their resolution, which I appreciate, which is this is a balance of interest. We actually think that the balance needs to be struck a little bit differently. It's the kind of thing reasonable minds can disagree on. But in looking at this, we are in line with what other states are doing in our proposal. This is not a radical proposal. This is not a leader of the pack type proposal. This is in keeping with what we see around the country. There's no question that there will be burdensome requests. There's no question. Whether you adopt and agree with us or whether you stay with what we have now, that is part and parcel of it. But just as we don't design the CPLR around pro se litigants who may abuse the system, you don't develop a system that's helping citizens and helping journalists by thinking of the most extreme cases. But here's the important point. FOIL already deals with that. Nothing in our proposal changes anything about how local government can deal with burdensome requests. There is in the law, section 89(3)(a), a provision that says if there's a burdensome request, the cost can be shifted to the requester. That's how it should be. We're not changing that. And that is an effective way to deal with these requests. And if you look at the cases, they come from places like New York, which I used to actually live in at one point. It comes from the city of New York. And so you sort of see it across the range of government agencies. And let me speak then to the second piece, which is, should there be deadlines for when, for instance, notices of meetings should go up, notices of public meetings? Should there be a deadline for when agendas should come up? Should there be basic documents of government available to citizens? We actually think these proposals help both government and citizens because the government doesn't have to answer 100 requests for where's the agenda. The agenda is available. But we think the timeline is important. And when we talk to people who are activists in local communities, journalists covering local communities, this ability to get information in a timely fashion was important. That's not surprising. Every level of government imposes deadlines on us, right? You have to pay your taxes by a certain date. You have to go to the polls by a certain date. If you're a litigator, you know the deadlines for the statutes of limitations, everything else. But I don't think it's unfair that the same burdens that are put on citizens are put on government as long as they're reasonable. And that's what we're talking about. We don't even set the deadlines in there. We ask that they just be specified. That's a good discussion we can have with people and come up with the right formula for that. So we've been at this for 2 years. We've heard from lots of people with various perspectives. We've had former FOIL officers on our panel discussions. And we think that these are modest changes that will help citizens, but more than that, since our focus is on journalism, help journalists cover local communities. It's a great crisis in our democracy. A lack of accountability in local journalism, a lack of accountability in local government is addressed by having active journalists who have access to information. We would ask you to support our proposal. And thank you once again for your support over the last 2 years.
Thank you very much for your report. At this meeting yesterday, the executive committee endorsed the report and recommendations of the task force. May I have a motion to approve the task force's report and recommendations?
So moved.
Second.
I have had a motion and a second. It's time for discussion. It's my understanding that there are several people who have raised their hands. I first call upon Allison Matthews. Please turn on your camera and unmute yourself.
Am I up?
Please see.
Okay. I'm in a hotel room in Maryland, so thank you for taking the time to call on me. I'm former chair of the Labor and Employment Law section, now a member of the House of Delegates, and I want to speak in support of the resolution of the Local and State Government Law section. On behalf of our members who represent employees, it's critical to them that records be carefully reviewed and properly redacted. There's information in those documents that municipalities are mandated to redact. On behalf of our attorneys who represent municipalities, we also have an obligation to make sure the information is properly redacted. And those governments also call upon us very frequently to make the redactions and to make them properly. Understanding the interests with local government, the recommendations to modify FOIL are seeking to change reality that oftentimes cannot be changed. As soon as the state repealed Civil Rights Law 50A last year, every single municipality that has a police department in the state of New York received very comprehensive, very burdensome FOIL requests for police department disciplinary records going back 50 years. I had the personal experience of having to help several municipalities review those records. They were stored in attics, they were stored in boxes, they were stored in basements, they were stored in old file cabinets. No one had any personal knowledge of what those records contained. They had to go through paper by paper by paper, and I'm talking thousands upon thousands of pages of records. There is absolutely no way that those records can be reviewed in the time that it takes. And oftentimes it's going to fall on the attorneys to try and make those deadlines. And you're putting us in an impossible situation. On top of that, I understand the issue with the fee shifting. In reality,
excuse me for a moment. Is there a motion on the floor that you're speaking to?
I'm
Or are you
speaking in
speaking to the
favor of
report?
I'm speaking in favor of the local and state government's resolution.
That resolution has not been presented yet. Are you
I'm-
presenting that resolution?
They're presenting the resolution. My understanding it was part of the materials. So I guess I'm speaking against the portions of the report on the FOIL modifications.
Okay, thank you for your comments. Until there is a motion on the floor with that resolution, I believe we are still speaking on the initial motion to approve. So I next call upon Stephen Leventhal.
Thank you. I am second vice chair of the Local and State Government Law section and an elected delegate from the 10th Judicial District. For those who do not practice in the area of municipal law, there are 62 counties, 932 towns, 534 villages, and 7,000 special districts in the state of New York. So the first message that I would like to deliver is that this is a report which, if adopted and implemented, would have profound effect throughout the state of New York. I represent mostly smaller municipalities, mostly villages, towns, to a certain extent, counties. It is not unusual for my municipal clients to have only 3 employees, typically a clerk, a building inspector, and a code enforcement officer. So for my clients, there is only one person who is in a position to respond to FOIL requests. And that person has all of the other responsibilities of running the local municipality. And in larger municipalities, the same problems exist, only on a larger scale. There is already a well-established body of law relating to both the Freedom of Information Law and the Open Meetings Law. You need only to go to the website of the Committee on Open Government. You will, if you click on advisory opinions, you will see an alphabetical grid, and virtually any topic of municipal law or practice will correlate to a string of advisory opinions that you can easily access using that website and grid. So this is a thoroughly established area of law. The proposal, if implemented, would impose unfunded burdens on local municipalities that are unrealistic, as you will hear more about, without advancing the stated goals of the task force, which is to address a crisis in local journalism. So I'm opposed to the report, and at the appropriate time, it is my intention to make a motion to table. Thank you.
Would you like to respond, Mr. McGraw or Ms. Acosta?
Yes, thank you.
Arado, sorry.
Yes, thank you so much. As we said, burden is addressed in the law. We're not changing that at all. To the extent that there is a burden, the procedures are there. The courts refer to it all the time. And I do have to disagree with the idea that somehow implicit in this is that the system is working well. I have not heard that from anybody, and that we're still waiting. We hadn't heard in 2 years an alternate proposal for dealing with delay. Given everything that we've seen over the last year, I would make my point again that this is a time for transparency. This is a time for government to do more. And this is a very modest proposal. It simply advances the timetable so that citizens and journalists can get information in a timely fashion. Can government still redact? You bet they can, and they will, and that's right. If there is a burden, then they should address that through the statute, just as they always have. I just think those issues don't really address the heart of what we're proposing here. Thank you.
Now, thank you. I now call upon Sharon Berlin.
Thank you. On behalf of the local and state government law section, I am the section's delegate, and I'm the immediate past chair of the section. And I want to thank you for giving me this opportunity to speak. First, I want to note that we are all for transparency and open government, and we do thank the task force for its report. It is our position that certain of the recommendations contained in that report do not strike the proper balance between the needs of the public, journalists, and local and state government. The recommended changes will present a tremendous unfunded burden on governments and their taxpayers, the potential costs of which are really not delineated in the task force's report. And it is our belief that the recommendations will not address the crisis in local journalism, which the task force was created to address. That crisis is not due to slow responses to FOIL requests or because a tiny municipality located in an area of our state that doesn't even have broadband access isn't posting their meeting agendas to a website. David mentioned that there's no question that there will be burdensome requests. I want to give you an example of what municipalities are really dealing with when it comes to FOIL requests. Most recently, these requests have been pertaining to police misconduct. One non-local, not a local news organization, it's a Massachusetts-based organization, has FOILed all materials and records regarding all allegations of misconduct made and all disciplinary proceedings taken against any officer, employee, or representative of the police agency, including internal, external, and civilian complaints, records of discipline, penalties, and use of force, all investigatory and disciplinary materials, witness information, photos, videos, and other related evidence, all personnel materials that reference misconduct allegations or disciplinary materials. And they seek those records going back over a 50-year period, going back to January 1 of 1970. Most of these
Ms.
records—
Berlin,
Yes.
I'm just going to let you know you have 30 seconds remaining.
The task force proposes a maximum of 40 business days to provide this information with no extensions. And there are attorney's fees for non-compliance. It's not a question of cost shifting. Local governments don't object to providing the information, but the proposal here is it's in an inflexible timeframe that cannot be met. I therefore have submitted a motion, and I would like to just read the portions of the motion and skip the prefatory paragraphs, which is a motion that the report be amended to delete recommendations 3C 1 through 4 concerning the Freedom of Information Law, and that the report be amended to delete recommendations 4B 1 through 3 concerning the Open Meetings Law, and be it further resolved that the report as so amended be received by the House, and that the task force be thanked by the House for the completion of the report.
Thank you, Ms. Berlin. Do I have a second to Ms. Berlin's
Second.
motion?
Second, Steve Richmond.
Is there any discussion on this motion?
Madam Chairman, it's Steve Richmond.
Yes, I received your second, Mr. Richmond. Just a moment.
Discussion?
Want to discuss?
Yeah, I did.
So I believe we have Jonah Treebrosser.
Thank you, Madam Chair, and hello to
Morning,
all
Your
my
Honor.
fellow. Good morning. I'm speaking now, not in my judicial capacity, but when I was one of the supervising attorneys in a regional office of the New York State Department of Environmental Conservation, we had 6 attorneys there. Myself and 4 other litigators who handled the permit and enforcement hearings, and 1 attorney whose job every day was devoted to reviewing files and responding to FOIL requests. And that's 1 field office of one of the smallest state agencies. The amount of material that has to be reviewed is voluminous. It has to be reviewed in exquisite detail to make sure that nothing from a confidential informant or a home address of an enforcement agent is accidentally released. It's voluminous, it's meticulous, and it costs the taxpayers money. I'm all in favor of full government. I'm sure everyone in the House is in favor of transparent and full disclosure government. Let's walk into this though with our eyes open. Municipalities are going to have to hire a FOIL person to respond to some of these requests, right? And as long as you understand that, understand also that a lot of people, at least of my acquaintance, when they retire, they move out of New York State because of the high level of state and local taxes. So this is not a no-cost option, right? In order to comply with the time limits, as Ms. Berlin has said, is going to mean additional staffing all across the board. Thank you very much for your kind attention.
Thank you, Your Honor. Mr. McGraw and Ms. Arado, do either one of you wish to respond at this time?
Not going to let me speak.
I just reply briefly that, again, there are provisions that take that cost burden off. I don't know why we're not focused on those, and why that isn't the response that should be given when there's a burdensome request. I see it all the time. And so this idea that burden and cost is somehow affected by a proposal is just not so. I'm also disappointed that the resolution is against giving more resources in 0.4 for FOIL. I don't understand why the resolution would oppose studying the fee shift. I know people have a lot of questions about it. We haven't proposed any changes in it. So it's a study proposal, and that's concerning. Finally, I'd just say, I appreciate everything that's being said about costs. As some of you know, I was in a prior life, I was deeply involved in local politics in Ulster County in the town of Esopus, where I was a precinctman. And I understand the cost problem. I understand the burdens. But I'll say what I say about voting. Voting is a very expensive process. It's worth doing, and we find the money to do it. I think the same thing about transparency and about FOIL. And our proposals are in line with what we see in the federal government and across the country. This is not a revolutionary proposal.
If I can add.
Thank you. I now recognize past President Hank Greenberg.
Thank you, Madam Chairwoman. And my deepest gratitude to David McCraw, Cynthia Arado, and the extraordinary group of people who have tirelessly over not 1, but 2 years to produce a report that has previously been before the House 15 months ago. And in response to that meeting, went on a listening tour to receive input from all sections and committees. I want to address and speak in opposition to the motion on the floor from the state and local government section. And I say this with the deepest respect, but the debate up till now, I say, and again, respectfully, has been skewered. We have heard from entirely the perspective of attorneys in government, of which I spent nearly half of my career. FOIL is one of the few things in life I know a little bit about. I've been a record access officer for state agencies. I've even litigated against Mr. McCraw, representing the government. I know well the challenges that state agencies and local governments face. 2 things I'd like to say. One is the proposal on the floor, so everyone understands, is vanilla. It is in line with what the rest of America is doing. It's not controversial, it's not radical. 2, we do have a crisis. We have a crisis in responsiveness to FOIL requests throughout the state. 3, and most importantly, the vast majority of lawyers who we represent for the New York State Bar Association, the vast majority are not attorneys that work for local and state government. They're attorneys in private practice who represent clients before state agencies who make FOIL requests. I am going to say without fear of contradiction, if we put a poll to the vast majority of our members, overwhelmingly, they would speak in support of this modest proposal on FOIL. So with the greatest of respect to my colleagues in public service, of which I continue to be deeply involved and have the greatest regard for, I think the criticisms you've heard are overblown. And my last point and my final point, in this era in which we now live, in which the public increasingly has come to distrust the government, the idea that the New York State Bar Association would stand anywhere but in favor of transparency and open government is mind-numbing to me. Thank you, Madam Chairwoman, for the time.
Thank you, Past President Greenberg. We have 8 remaining. I'm going to close the hand raising at this point because if I allow it to continue, we will go into the early evening in this meeting. I'm going to call on the remaining 8 people. I ask you to please try to keep your comments as succinct as possible. I'm going to start with Peggy Finnerty.
Thank you, Madam Chair. I want to echo what past President Hank Greenberg said. I am in total agreement with him, which is not unusual. By the way, I'm sorry, I should mention that I am currently a delegate from the New York County Lawyer Executive Committee as of June 1, and I had the privilege and honor of being the Executive Committee liaison to this task force. I want to commend David and Cynthia for an outstanding job and all of the members of the task force, and in particular for reaching out to the various constituencies in the bar, especially the local and state government law section as they put this report together. I think that's something that all task forces and committees and sections should do when they're preparing reports. But I speak in support. I'm very sympathetic to the points raised by the local and state government law section. But transparency and access to information is just too important. And the report does recommend that the state provide the necessary funding to comply with the timetable, the modest timetable that is being recommended. And it's my understanding that there are safety valves if it is too burdensome. So I think that's important to keep in mind. You know, it's not just the press that's affected by this. I work in the area of the False Claims Act. It is not unusual to want to FOIL information in order to file whistleblower suits to expose fraud against the government. I personally have encountered months and months and months of delay with FOIL requests. With respect to the proactive transparency for local meetings and providing basic information on government websites, That is just key. Most people get their information on the internet now, and it's no different for people who are trying to find out basic information from their local government. Many people live far away from perhaps their city hall. Maybe people are incapacitated. Basic information must be on the website for their local government agency. Likewise, for the open meetings, it's key that information be provided and that people be allowed to participate via Zoom or the internet. These local meetings pertain to zoning issues, policing issues, school issues. How can the public meaningfully participate if they don't have access to the necessary information, which from my personal experience, having participated in these meetings is not that difficult to do. So I think the time is now. When there is a deadline imposed, somehow people manage to meet that deadline. And as I said, if there are obstacles to doing that, there are ways of addressing that in this report. So I urge the adoption of the report and the recommendations. Thank you.
Thank you. Susan Harper is next recognized.
Yes, thank you so much. I appreciate the time to be able to address you today. I am a member of the Task Force on Free Expression. And first, I want to commend David and Cynthia for their leadership and Hank for recognizing this issue, as well as the EC for their support of this report. Just a little bit about my own background that some of you may not be aware of. I am a former reporter. I was a former reporter and legal editor with the New York Law Journal. I'm also a taxpayer who has used, freedom of information requests to find out information that's happening in my local government. We can all agree that a delay in information can be exceptionally frustrating. Yesterday, I just heard from a New York State Bar member discussing an information lag just here at the New York State Bar, that he felt frustrated that it was limiting him in terms of decision making. And then he felt like he was in the dark. And how wonderful we can all agree that when standard information is available, the agenda, meetings, reports, like we all have when we come to this meeting, so that we can be prepared better to do our jobs, weigh in a timely manner. And as the gentleman just talked about reading the report late at night on the Task Force for Police Reform. Our task force report embodies these same concepts so that journalists can do their jobs and that taxpayers, the public, can have transparency to in government decisions in a timely manner that may impact their communities, our health and properties. When there are delays, decisions cannot be made and rights are often waived because of the fact that people don't have the information and journalists need that information in order to uncover and inform our public. Our reports also supports evolving the nonprofit press and the great skill set and talent that our membership can offer to support the nonprofit associations. The task force reissued this tabled report, removing several recommendations, issues that were brought up. It is exceptionally narrow, as Hank has mentioned, from the FOIL reform to smart disclosures before meetings and to support for non-for-profit and for the press and legal support. The task force, the amendments as put forth should be denied. The proposed FOIL reforms and smart disclosures, which would reduce the need for FOIL requests and costly litigation that is burdening these municipalities. And that way, and report that advocates for greater resources and support too. So that way, municipalities in addressing these issues, there's more efficiencies when having to share this information. This report has been ongoing for 2 years, and many people have been involved in weighing in and have had the opportunity to reach out. It should be accepted, and any amendment should be absolutely denied. Thank you.
Thank you. I see that one of our presenter, Ms. Arado, you have your hand up. Would you like to respond? You're muted.
I think I'm unmuted now.
Yes, you're good now.
Yeah, I'll just respond briefly and not to those most recent remarks, but most of the objectors for the state and local government section have been talking about this recent flurry of activity for Section 50A. I think the repeal of Section 50A is a one-time transformational event. And I don't know that the fact that there's a flurry of activity, given the fact that 50A was on the books for so long, is really a reason to object to what we're proposing to be a long-term change across all types of FOIL activities. I think the repeal of Section 50A should have happened a long time ago, and it didn't. And I will note that, you know, along with what David and other people have said about how the recommendations we're making are not radical, they're in line with what many other states do. The recommendations in our report last year when it was tabled are akin to that. We had recommendations to amend the anti-SLAPP law of New York, and we also had a recommendation at that time to repeal Section 50A. The report was tabled, and the legislature in the ensuing summer actually enacted our recommendations, but they did it without the New York State Bar Association having a voice. And we lost the opportunity to be part of that group that supported that important change. And I just urge the House of Delegates not to do that again. I think we are proposing changes to provide openness and transparency that are really needed at this time, and that this organization should be the party supporting that and not impeding it. With respect to the resolution, it's effectively a straight veto. We understand it's very heartfelt and we hear the reasons why, but it is not proposing anything as an alternative. And for that reason as well, we think it should be denied. Thank you.
Thank you. I next recognize past President Michael Getnick.
I was going to address some of these matters, but they've already been addressed by some of the speakers, so I will yield my time so other people can be heard.
Thank you, past President Getnick. I will next recognize Laurel Kretznick.
Good morning, everybody. I'm Laurel Kretzing. I'm a member of the House of Delegates from the Commercial and Federal Litigation section, and I'm a past chair of the Commercial and Federal Litigation section. But I'm speaking today from the perspective of my day job. I'm the Bureau Chief of Litigation and Appeals in the Nassau County Attorney's Office. We litigate FOIL matters every day. We're extremely familiar with the FOIL regulations that exist, and the FOIL law as drafted now is a carefully balanced structure that weighs heavily in favor of disclosure. Inserting the 40-day hard deadline into this structure does nothing to advance the cause that this particular task force was designed to address, as I understand it. But what it will do will burden the municipality, force the municipality into directing limited funds to addressing FOIL requests in a hurried manner. And that's very detrimental, not only to taxpayer funding, but to other concerns that FOIL is designed to address. And the notion that this 50A repeal is a one-time flurry of activity is very misguided. 50A served as a shield to certain documents for many years, but the FOIL law itself has exemptions in it. And those exemptions are now going to come into a larger play because 50A is gone. I don't think that this is the time in the state's evolving address of public information to insert this kind of hard and fast restriction on FOIL responses. And I'll cede any remaining time to anyone else.
Thank you. I next recognize Lavonda Reed. And again, I mentioned that we are well over time. So if you can keep your remarks, please, under 3 minutes, that would be appreciated.
Certainly, thank you. I'm LaVonda Reed. I'm Associate Provost for Faculty Affairs and Professor of Law at Syracuse University College of Law, a member of the House of Delegates, and also a member of the task force. And I want to thank past President Hank Greenberg, as well as our co-chairs, David McCraw and Cynthia Arado, for their leadership on this particular project and the report and its recommendations. We held, as you heard, many town halls, and what became very apparent is this is a confluence of a number of challenges and burdens, as we have heard from some of those who have spoken earlier this morning. We also heard very much that the system is not working. We have a balancing, if you will, of not only the rights of journalists and newspapers and news information services, but that of civil rights, access to information, access to justice. And so that is to be juxtaposed against what we've heard very loudly was the burdens on state and local governments in complying with FOIA requests. But in my mind, and I think the committee's mind, the balance tips in favor of access, transparency, and access to rights and information and justice. We have been told by past President Hank Greenberg just a few moments ago that government can do more and government should do more. And this proposal gets us towards that end. It is not lost on any of us that there is a substantial burden there, but correct that and make this possible. That concludes my remarks, and thank you. I'll cede back the remainder of my time.
Thank you. I now call upon past President Tom Levin.
Thank you. I'm going to try to be brief. I'm not only past president, I'm speaking from my perspective of my multiple day jobs. I represent a number of municipalities on Long Island as a village attorney. I represent a number of municipalities as special counsel, and a substantial part of my practice is in the private sector, in which I make FOIL requests quite often. So I'm a consumer of FOIL as well as a government attorney, and in one particular village, I am for 15 years the records access officer. So I think the problem with this situation is that this current statute was intended to be a balance of the respective interests, and no balances are perfect. You try to do the best you can, but I think the proposals that are being made here tilt the balance. I'm concerned that there is no data backing up any of these proposals. What we're getting is anecdotal evidence. So let me bring some of my own anecdotal evidence to play. In the one village where I'm a FOIL officer, a small village, we get an average of 10 FOIL requests a day. This requires numerous personnel in the village to go searching for records. They have to locate them, which very often are in storage in other locations. The records they don't just simply get turned over, they have to be reviewed. As was pointed out by previous speakers, there's material in them that is exempt by statute. We're not allowed to disclose it. We have to identify that. We get two of the villages I represent have police departments. We don't have 50A issues. I'm not speaking to that, but we get lots of requests for arrest records, police reports, investigative material, all of which has to be checked out to see if the records have been sealed because of prior dispositions of cases, and so on. It's just simply not possible, even in, and this is a sizable village, even in a sizable village, to comply with the timelines of existing law or the proposed law all the time. We do most of the time. I would say that we answer 75% of our requests within 5 days, 90% of our requests within 20 days. We occasionally have requests that we can't answer in 4 months. The comment that if a request is burdensome, the costs can be shifted to the requester is not true. But the statute, I believe that reference was made to, provides that if the cost of preparing a copy of a record would exceed 2 hours, that cost can be shifted to the requester. But nobody knows what preparing the copy means, because the statute provides you cannot include the time to search for the record. You cannot include the time to go through the record to redact the portions that are not to be disclosed. You cannot include the time that it takes to make the copies or prepare electronic scans. and then
Past
send them out.
President Levin, I'd ask
Yes,
you to
I'll
wrap up
try
your
to
remarks.
conclude. So the bottom line is basically in smaller governments, as Steve Leventhal mentioned, there's very little staff. Very often the staff is part-time. These proposals, while well-intentioned, are going to put tremendous burdens on most of the local governments in the state. We're not all the state of New York, the city of New York, or the counties with huge staffs. These are very small governments. We'd be happy to find ways to try to make the process work better, but I'd submit the process is actually working. There's no data here to show to the contrary, and we're using an elephant gun to kill a mouse. Thank you.
Thank you. Again, if for the remaining commenters, please try not to repeat what has already been said. I'm next going to call upon Steve Richmond. You're on mute, Steve.
Sorry, Madam Chair. I'm the delegate from the Entertainment, Arts, and Sports Law section, but I'm speaking now. I just concluded a 35-year career in state and local government. And in every position, I was either the Records Access Officer or the Records Access Appeal Officer. 3 simple points with the report. One, while the attempt, I think, is good, it doesn't cover everything. There's no attempt now to expand the definition for the open meetings law to cover some of the administrative bodies of the court system. So, for example, we're going to come up with an issue later when the administrative board of the courts issue the rule. There's no public meeting notice, etc. They want to serve the media. Let them start covering that and push for that change. Secondly, the types of requests can be burdensome. The last year during the pandemic, when I was at the Board of Elections, people were at home doing their Ancestry.com requests, and we got over 1,000 requests for copies of a voter registration record going back to 1900, 1910, which are kept in old, large ledger books. And what Mr. Levin said, I agree. The staff at the Board of Elections in the city of New York, the largest board in the state to do the work, was 1 part-time staff member plus the 2 lawyers to do the review. It is burdensome. And finally, in response to the co-chair's comment that we fund elections because it's necessary, that's not true. Elections aren't necessary, they get done. But adequate funding has not been done, and calling for it without providing a specific dedicated source of revenue to be included in that stream just will create an unfunded mandate. I support the resolution in the section of local government.
Thank you. I next call upon Elena DeFeo-Kane.
Good morning, everyone. I think it's still morning. Elena DeFeo-Kane, elected delegate from the 3rd Judicial District. I too, I will echo what Steve Richmond said, as well as past President Tom Levin. I represent small local governments as well as use FOIL. And I rise in support of the amendment of the state and local government section. This goes beyond the extent of the report, but it needs to be looked at closer. And I think it's going to put undue burden on small municipalities. And I think in the absence of data demonstrating that there really is a problem, I think that this is far beyond the scope of what needs to be accomplished today. And so I would rise in support of the amendment. Thank you.
Thank you. And lastly, I'm going to call upon past President Vincent Doyle. You're on mute.
Okay.
Now you're here.
Can you hear me now, right? All right. So thank you, Madam Chairperson. Past President Greenberg read my mind. It's not unusual. I'm a private attorney, so I don't have the same background as others who have spoken, who represent local and state governments, but I often try to use FOIL, and there is a crisis. I have never received a timely response to any FOIL request that I can recall. The responses are normally inadequate as well. That's a different issue. But there is a crisis in terms of the timeliness with which government entities respond to FOIL requests. And to those lawyers who have spoken out, who represent local and state government, I appreciate what you've said, and you've said it in good faith, but your clients are us. The government is us. These are our records. And we have made a policy decision that these records should be available to the public. And to the extent that there may be additional cost or additional time to your clients, which are our government entities, then the government should bear that and the taxpayers should bear that. So that is not a reason to oppose the task force recommendation. I fully support it, and I oppose local and state government law section recommendation, which I think carves the heart out of the task force work. So thank you.
Thank you. At this time, I'm going to call the question as to the resolution presented by the state and local government law section. It was circulated, I believe, in the last day or so within the materials of the House of Delegates. It was presented by Sharon Berlin. We have a motion and a second. We have had discussion. At this time, I'm going to ask for a vote on the motion presented by the state and local government section. We will now take a vote. The poll window is appearing. Please. I'm sorry, I'm looking at my computer screen that is glitching, but we will leave it up for a few more seconds for the vote to be completed. Aye, nay, or abstain. Okay, the polling has concluded. The motion passes, correct? Yes. Okay. Sorry, the motion carries 51% to 42% with 7% abstentions, and I'm reading that because it is close. I know.
Thank you.
So we now are going to put up a poll to vote on the approval of the report as amended by the resolution that was just presented.
Madam Chairperson, this is Steve Leventhal. I had made a request or indicated my intention to make a motion to table. I withdraw that proposal.
Okay, thank you, Mr. Leventhal. Again, we will put up a poll now on the original motion to adopt the report of the task force.
As amended?
As amended, I said that the first time. I apologize if that was unclear.
Well, that's not what the motion says.
The poll.
Yeah. It is a motion to approve the amended report. We just are not able to change the language on the screen because the motion was put up initially. So it is a motion to approve the amended report, and the minutes of the meeting will so reflect that. So as amended by the resolution that was presented and adopted in the immediately preceding motion. Okay. We are now closing the polling, and the motion carries to approve the report as amended by the resolution presented by the state and local government section. State and local law government section. Thank you all. We are now moving on to the next item on the agenda. This is the task force report on the New York State bar exam. The task force was appointed in 2019 to review the impact of New York's adoption of the uniform bar exam. Its report was approved by the House of Delegates in April 2020. A second report relating to the impact of COVID on July 2020 administration of the bar exam was prepared and considered simultaneously with the first report. It also was approved by the House in April 2020. In this third report, the remote administration of the exam and the long-term future of the New York bar examination are addressed. The report will be presented by the task force chair, the Honorable Alan Shankman. Thank you, Your Honor.
Thank you very much, Madam Chair. I have the privilege on behalf of the members of the task force, whom I thank for all of their hard work, to present what is our third report. Just as by way of a reminder, the key recommendations of our first report, as the chair reminded us, which were adopted by the House, was the elimination of the New York law exam, which is an open book, online, on-demand test consisting of 50 multiple choice questions. We recommended that applicants for admission in New York have to pass a rigorous test on the New York law, that and that consideration be given to a New York law certification program under which students who graduate from law schools accredited by the ABA with enough credits in New York law earned with sufficient grades could potentially forego an examination, and likewise to consider a program under which students who spend significant time during their second and third years of law school in supervised practice in New York and whose activities are monitored and graded by law school faculty could gain admission without examination as well. We also called for the retention of an independent psychometrician to analyze the grading and scoring issues with the with the UBE. As our first report was being considered by this body, the COVID-19 pandemic struck New York in full. President Greenberg asked that we consider the impact of the pandemic on the July administration of the bar exam. And as the chair kindly reminded us, we issued a second report. All of the recommendations of which were adopted by the Court of Appeals within 48 hours. However, some of the recommendations were overtaken by events. New York had planned for an in-person bar exam in September of 2020, but imposed capacity limits. Due to those capacity limits and uncertainty as to whether or not the examination would be conducted at all, applicants were encouraged to register for the UBE in other UBE states. A scramble for seats ensued as bar authorities struggled to find a way to allow 2020 law graduates to enter practice. Many law school deans, faculty, and students advocated for diploma privilege, that is, admission simply on the strength of having passed a law school course. Eventually, the National Conference of Bar Examiners, the NCBE, agreed to produce a scaled-back iteration of the bar exam to be administered remotely in October of 2020. Grades were not portable, but New York reached reciprocity agreements with a number of other jurisdictions. The efficacy of the October 2020 remote exam was questioned both before and after it was administered. A remote exam was also administered in New York in February 2021, this time a full UBE. The forthcoming July 2021 exam will also be remote, and the NCBE has just announced that it will not produce any further remote examinations. As these developments occurred, President Carson requested that we remain engaged on the various topics. We studied the developments. I, together with members of the Committee on Legal Education and Admission to the Bar, participated in a virtual forum with law students on the issues of diploma privilege and bar examination, and that is a dialogue that has continued. We maintained, as the chair was kind enough to point out, our focus on the long-term issues, receiving a thorough briefing from Professor Deborah Merritt of Ohio State on her October 2020 report, Building a Better Bar, a work that she prepared in conjunction with the Institute for the Advancement of the American Legal System. Professor Merritt also was kind enough to give us a detailed proposal as to the form and content of a proposed New York separate exam. Professor Merritt's study made four important findings as to the work of new lawyers. First, that state and local law plays a prominent role in their work. Second, that new lawyers frequently engage with clients. Third, that new lawyers rarely rely on memorized rules. And lastly, that new lawyers often assume substantial responsibility for client matters within their first year of practice, often with little or no supervision. Her study identified 12 building blocks, that is, key components of what lawyers do, and those are laid out on the screen and are presented in our report. The Merritt study pointed out that written exams assess only about half of those building blocks. For example, a written test does not evaluate basic listening comprehension or project management skills. That multiple choice questions, while more efficient to grade, do not measure the cognitive skills that lawyers use in practice. We also point out that in our first report, we indicated that for some reason, men tend to do better on multiple choice questions and women tend to do better on essay questions. So when exams such as those done by the NCBE give weight more to the multiple choice questions, they tend to discriminate against women. The merit study recommends that more performance tests be used, that consideration be given to open book exams, that applicants should have more time to answer questions, and that law schools should require courses in client interaction, negotiating skills, and clinical work. In January of 2021, the NCBE issued its preliminary recommendations for what it envisions as the next generation of bar examination. The new proposed bar exam would eliminate the components that presently exist, that is the multi-state bar, the multi-state essay, and the multi-state performance test, and replace them with a single integrated examination. While it would still be a 2-day test, candidates would receive only one grade. That is, each day would not be graded separately. As a practical matter, this eliminates the option that we had proposed in our first report that New York essentially go back to where we were prior to the UBE, with 1 day of multi-state testing and 1 day of New York testing. The NCBE's new exam would use a combination of multiple choice, true, false, essay, and performance tests, that it would test what the NCBE regards as foundational concepts germane to a general license. The new exam would drop from the subjects now tested, the subjects of family law, trust and estates, the Uniform Commercial Code, except for Article 2, and conflict of laws. The examination would be closed book. The examination would be, quote unquote, computer-based. Let me explain what is meant by that. It has been longstanding that candidates can complete their tests by using a computer. What would be new is delivery of the test materials strictly by computer. While it is true that that has been done in conjunction with the remote exam, the NCBE would make that permanent. And they would take 4 to 5 years to develop the new exam. On April 12th, our task force issued its third report, which contains our updated and revised recommendations, which are: we reaffirm, first, our central recommendation that applicants for admission for practice in New York be required to demonstrate basic knowledge of New York law as measured by the passage of a rigorous test on matters of New York law, or by extensive law school study of New York law, or by extensive supervised clinical practice of New York law. We recommend against the continuing de-emphasis on state law, particularly since the merit study shows that newer lawyers rely more heavily on state and local law than federal law. We recommend against the elimination of testing of family law, trust and estates, most of the Uniform Commercial Code, and conflicts of law. The experience in New York shows that when subjects are dropped from bar testing, students do not take courses in these subjects. Law schools discontinue faculty who teach those subjects, and academic interest and scholarship in those subjects drops. I'd like to speak for a moment, in particular with regard to family law and trust and estates. Those are bread and butter issues for general practitioners. Even, however, if someone does not intend to practice in those areas, knowledge of family law and knowledge of trust and estates, we believe, is vital for the lawyer as a public citizen. Unfortunately, divorce rates remain high. The issue of domestic violence is constantly before us. For a lawyer not to be educated and tested and having a basic understanding of matters relating to family law and domestic violence, we think would be a serious loss. Likewise, death is inevitable. And for lawyers not to have a working knowledge of the laws of trusts and estates would also be a serious loss. We also do not recommend the administration of the bar exam by computer as a permanent form of delivery, at least at this time. Serious objections have been raised with regard to this format. The NCBE issued its recommendation to make this format permanent in January without even having bothered to study the impact of remote delivery in the one time it had been used prior to its making of its recommendation, which was in October. Testing can be very daunting when dealing with the materials provided by computer. For example, a performance test, which everyone seems to recommend that be included on tests these days, test takers are provided a 25-page or so library of materials. Then to answer this question, a candidate must have open on their computer screen the 25 or so pages of PDFs. They must also have a word processing document open, which contains their drafted answer. And many will also want to have a separate note area, 3 separate areas on a computer page, single computer screen that all have to be navigated. We are concerned that the use of a computer-only delivery format may be unfair to persons with cognitive disabilities. We are concerned that if candidates are permitted or required to use their own computers, applicants with better, more up-to-date equipment may have unfair advantages, and that if candidates are required to use standard equipment at test centers, they may be unfamiliar with such equipment, and the cost of administration may be prohibitive. We are concerned that the time examination, particularly under the tight timeframes that the NCBE gives to answer, may become more of a test of computer skills than of legal knowledge. We are also aware of some studies that have indicated that shifting the distribution of test materials from print to digital, particularly in the form of PDF files, has negatively impacted comprehension. There may be issues about how one navigates within a document. Moreover, some forms of computer-based reading may be better than others. For example, LCD computer screens are known to cause visual fatigue, while ebook technologies, such as those used by Kindle, are merely reflecting ambient light and may be more reader-friendly. We believe that this whole entire area requires much more study before it is made permanent. We also remain concerned about the NCBE scoring practices. We believe that the bar exam should be used to measure whether an individual possesses the minimum competency for law licensure, not whether that individual has a knowledge base that is stronger or weaker than most of the others who took the test at the same time. Under the NCBE scoring practices, a person can be the strongest of the weak candidates and found competent, and vice versa. A candidate can be the weakest of the strong candidates and still be found not competent. So we continue to object to the use of a scoring mechanism, which may result in the grant or denial of a law license based on grounds other than whether the particular individual in question has demonstrated competency. This unfairness is compounded by the fact that states set their own and different passing scores, under which a score can be a pass in one jurisdiction and a failure in another. So in sum, we believe that New York should use the 4 to 5 years during which the NCBE is retooling its examination to develop its own. If we do not, then we will be stuck with whatever the NCBE chooses to develop. We call on the Court of Appeals to appoint a working group to develop the new test, which we believe should include at least one performance test, should include essays to test New York law, as well as emerging areas that are not tested by the NCBE, which are nevertheless vital to the forthcoming generation of lawyers: health law, immigration, and cybersecurity. Test sessions, we believe, should be longer than the 90-minute sessions allowed by the NCBE. Candidates should have more time to answer more thoughtful questions. We believe there should be a test on New York civil procedure. Too many lawyers have been admitted to practice in New York without knowing much, if anything, about our complicated court system. But rather than perpetuate rote memorization and the discriminatory impact that multiple choice questions have upon women, we recommend that the civil practice portion of the exam use either short form or traditional essay questions, and that candidates be permitted access to statutory materials during the test. The test should not be delivered solely by computer. At the very least, candidates should have the option of having the test material in hard copy. We also urge examination of 2 additional pathways to practice, one through a concentrated study of New York law while in law school, secondly, through clinical supervised practice while in law school, which can be a combination, a complement or an expansion of the existing pro bono scholars program, which is presently open only to third-year students. In fact, in the future, consideration may wish to be given to requiring one or both of those, one of those alternative pathways in addition to a test, since we know that written tests do not study or examine all of the aspects of what is required for legal practice. So that is a summary of the key points of our report, and I would be honored to take any questions, and I thank you for giving me this time. And again, I thank all the members of our task force and the members of the NYSBA professional staff who work with us on this endeavor.
Thank you, Judge Shankman. At its meeting yesterday, the executive committee endorsed the report and recommendations of the task force. May I have a motion to approve the report?
Second.
I have a motion and a second. We will now open the floor for discussion. The first I call upon and recognize Ron Minkoff. There we go.
Yes, hello, sorry about the delay. This is Jai Chandrasekhar. Thank you.
That's Jai. Okay, that's fine. That's fine. It looks like Mr. Minkoff was having trouble with his video. So Jai, we'll start with you. If you just could identify yourself and your affiliation, then we'll go back to Mr. Minkoff.
Yes, sorry, Ron, to jump the line. Jai Chandrasekhar, I'm a delegate from the New York County Lawyers Association, speaking only for myself. Thank you for recognizing me, Madam Chair. I'd like to thank Justice Shankman and the members of the task force for their very thorough and excellent report. I initially had serious concerns about it because, like many New York lawyers, I went to law school outside New York State, at a school that did not teach any classes in New York law. And so I had to take one of the commercial cram courses to squeak through the New York bar exam, which I fortunately did. Justice Shankman kindly addressed that concern at an informational meeting and had a number of very trenchant responses, one of which particularly resonated with me, which was to encourage the law schools in New York State to cooperate with out-of-state schools to make New York law classes available to students going to school out of New York State, which I would certainly hope that the law schools and the court system would all agree is an important component of this if we're going to require out-of-state students coming into New York, as so many do, to pass this rigorous New York bar exam. I happen actually to be skeptical about the whole concept of the bar exam, but given that we're not anywhere near the stage of jettisoning having a bar exam, I certainly agree that we should have a high quality bar exam, and I support this proposal. Thank you.
Thank you. I next recognize Ron Minkoff.
Thank you. This is Ron Minkoff. I'm a member of the New York County Lawyers Delegation and a member of the Executive Committee. And I'm presenting my own views on this. My views on this are based on the fact that I am a professional responsibility lawyer. Our firm probably does as much work with admittees and potential admittees to the bar as anyone. I have really struggled with this report. I've studied it extensively. It's 122 pages long, and there are a lot of recommendations. But my main concern is, as it has been since the beginning of this project actually, is that this association 17 years ago, under the leadership of Steve Crane, took the position that we were going to encourage multi-jurisdictional practice. And we spent 15 years beating our head against the wall of the administrative board until Judge Lippman finally adopted the multi-jurisdictional practice rules. When the association initially agreed to the UBE, it was, in my view, a positive step in making our practice, the practice of law, more national and the ability of people to move from state to state more available. I agree with the commission that the New York law exam component of the bar exam has failed. It is not adequate and it needs to be strengthened. But what I cannot agree with, and I'm not really sure that the report goes this far, but what I can agree with is jettisoning the UBE entirely. It performs a valuable function in making New York integrated into the rest of the country as a way for people to practice and to move across state lines. And therefore, to the extent that the report is saying to throw out the UBE and to not keep it in some form, it would be wrong. I think we should keep the UBE. I think we should continue to negotiate with the NCBE because they need us as much as we need them. If they lose New York, that's a big blow to them. So we have a lot of leverage in that discussion. We should keep on them to make this the bar exam work, but we should also strengthen the New York side of it, but we shouldn't jettison the UBE. So I'd ask for clarification from Justice Schenkman on that point, whether we're jettisoning the UBE or are we keeping it and strengthening the New York law exam?
If I could respond, I thank you, Mr. Minkoff, for having taken the time to review our report and for your insightful questions and express concerns. Initially, I would point out that our association did not agree to the UBE. Our association's position was that the rush to adopt the UBE, which was undertaken by the then Chief Judge, was premature and that it needed to be more thoroughly examined. So we didn't exactly oppose it, but we didn't exactly agree to it either. With regard to your question about jettisoning the UBE, our original report suggested that we should try to have a compromise. The issue here was, how many days of testing do you have? The UBE is 2 days. If we had a New York day, those who wanted the UBE and admission in New York would then have 3 days of testing. So we had proposed that those who wanted to practice in New York only, which is actually the majority of people, most people don't take advantage of the portability, could take 2 days, take the multi-state and the New York day, that those who only wanted to practice someplace else could take the full UBE. And those who wanted the benefit of all the worlds could take the 3 days of testing. However, because the NCBE is now moving to a system where they are not going to have separate portions of the exam, and they're going to have one 2-day exam with one score, the NCBE will be making that impossible. Yes, if the NCBE would reconsider its position, we might well be able to go back to what our original recommendation was. I am not wildly optimistic about how we can influence the NCBE, bearing in mind that those who represent New York on the NCBE come from the State Board of Law Examiners, which has not embraced our position.
Thank you, Justice Schenkman. And the last hand that I see raised is Ann LaBarbera.
Hello, Ann LaBarbera, the chair of the Young Lawyers section. I'm speaking in my personal capacity. I just wanted to emphasize the point that taking exams on computers is something that can be very difficult for people with some certain disabilities, and I have a seizure disorder. So on a good day, sitting on a computer for 2 whole days is going to make my brain very tired and would probably make it very difficult to pass a bar exam. No matter how well prepared I am, on a bad day, it could actually induce a seizure. And thankfully, I don't have generalized seizures, but some people who have seizure disorder might actually have to be taken to the hospital because they've had a seizure. So I just wanted to emphasize that it can be a very serious issue to force someone to take an exam on a computer. And thank Judge Schenkman for bringing that to everyone's attention. I just wanted to emphasize it.
Thank you, Anne, for sharing. I apologize. There was one other hand raised in the queue, and that is past President Michael Miller. I recognize your. Michael, you're on mute.
Yes,
Okay.
thank you. I'll be very brief. I just want to thank Judge Schenkman and the entire task force for this extraordinary service they've provided for the New York State Bar Association, but even more for our community, the people we serve, and the future of our profession. I believe this report is more than important. It is vitally important. It is, it gives the New York State Bar Association the leadership on the future of our profession in a very meaningful way. Judge Schenkman has been, I've attended every meeting of this task force, and I can tell you he has devoted countless hours to this effort, and his consensus building. This task force has a broad range of members with different backgrounds, different ideas, people from academia, people from government, bar leaders from around the state, and the consensus building that Judge Schenkman has accomplished in achieving this important report, this third report, is really exceptional work. I also want to recognize another member of the task force, Michael McNamara, who a lot of the drafting burden fell on his shoulders, and both not only for this report, but for the previous two reports as well. And he's played an important role in the work of this task force and the work product of this task force. So Justice Schenkman, again, thank you so much for your contributions on this incredibly important topic.
Thank you, past President Miller. At this time, I'm going to call a vote for the motion that's on the floor. The poll will now appear on your screen. I think you guys are getting used to this, so I won't repeat all the instructions. But we will leave it there for 30 seconds as we tally the votes.
Okay, you said I had to say something. I said something.
Michael, you're not on mute anymore. I mean, you're.
Whoa.
All right. So
Moving along.
the motion passes. Thank you, Justice Schenkman, for your report. We now move to the next item on the agenda. The next report on the agenda is the Committee on Standards of Attorney Conduct. The committee is presenting a report recommending the amendment of Rule 8.4G of the Rules of Professional Conduct. The comment period for this rule ends at the end of next week. The report will be presented by committee member Professor Ellen Yaroshovsky, as well as consultant Deborah Raskin. As Ms. Raskin is not a member of the Committee of Standards of Attorney Conduct, I am sending her the privilege to the House to speak at the House. Thank you.
Thank you. Can you hear me? Ellen, are you on?
We can hear you, Ms. Raskin. I don't see Professor Yaroshovsky.
I think that actually there was some confusion because we were given an earlier time, like 1:50. And I logged in because something just came up advising us. You know what? I could phone Ellen, perhaps.
Sorry, why don't we do this? Ms. Raskin, if you want to try to reach out to Professor Yaroshovsky, and we're going to try to proceed with potentially the next item on the agenda.
Okay, I'll call her.
And then we will call upon you as soon as that is completed.
Okay, terrific. Thank you.
Okay, great. So thank you to Mr. Fernandez for being early and signing on for the report. We will now proceed to the report, which is item number 11 on the agenda, the report and recommendations of the Task Force on Nursing Home and Long-Term Care. This report, by way of background, the task force was appointed in 2020 to review long-term care sector pandemic experience. The report will be presented by task force co-chairs Hermes Fernandez and Sandra Rivera.
Good afternoon. I just want to say thank you to past president, immediate past president Scott Carson for appointing Hermes Fernandez and myself as chairs of this task force. The task force was a very diverse group, and we appreciate that. We appreciate all of their comments. We had members from the elder law section, the trial attorneys, business attorneys, members of the Disability Rights Committee, and health law section. And that was important because they all played a role in what we had witnessed over the last 15 months in terms of what was going on in the long-term care environment in nursing homes, but also in other environments as assisted living facilities and those licensed facilities by the Office for the Prevention of Office for People with Developmental Disabilities, as well as the Office for Mental Health. And so we really leaned on a lot of our committee members, all of our committee members, quite honestly, for their input. And because of that, we had a wide-ranging discussions from vast different perspectives. And because of that, when we were really looking at, how do we tackle this issue of what happened and what can we recommend, we really wanted to bring together folks who could agree on the list of recommendations. And so what Hermes will provide brief soon is just a highlight of some of the recommendations. But I think it was just important for you to get a sense that we did what we could as far as going as far as we could to assure that we were reflective of the sense of our task force. And we also had to keep our focus. A lot of the issues that were raised were, and rightfully so, they were happening even before the pandemic. And what we were witnessing is that when we were going through the last 15 months, it was just exacerbating some of the underlying issues. But understanding that and understanding what our mission was, which was to really focus on how COVID-19 was impacting long-term care, we really had to sort of really focus in on our recommendations. And our focus was also on the patients. We recognize the great sacrifice and cost paid by healthcare workers throughout this time period. But we really wanted to focus on the patients, understanding that the healthcare workers were putting their lives at risk as well to do their job. And we also understood that the disproportionate impact on certain minority communities and we were very sensitive to that. But because we were doing this in real time, we were trying to sort of analyze what was going on while we were going through it. The data just wasn't there yet. And so we were looking for a lot of help from those who were witnessing what was going on. And so we have some limited information specifically as it relates to communities of color, but we did try to find and where we were able to make that recommendation and note it, we did. So considering the time is late, I'm going to keep my comments to that. I'll let Hermes just talk briefly about our recommendations, and then we'll take questions.
Okay. Thank you, Sandra. Good afternoon, everyone. I notice that Sandra gets a podium. I don't, but despite the unfairness of those two spots, I'll do my best being seated. We have made a number of recommendations, and as Sandra pointed out, we had a diverse group, and so our recommendations reflect the diversity of thought in our group. The principal recommendation that we made, and we think this is extremely important, is the COVID-19 pandemic, as Sandra said, revealed the limits of the current long-term care system. It exposed whatever weaknesses were there, they were all exposed. So our primary recommendation is to rethink the delivery of long-term care. Today, if you were being discharged from a hospital and you needed continuing care, it's most likely that you would be told it's time for discharge. Here are 5 nursing homes which would be willing to admit you. We don't think that nursing homes should remain the center of long-term care. Our proposal is to rethink this, and let's take a look at what has been working successfully for others. And we see that there are people with very complicated conditions who receive care under the licensing and certification of the Office for People with Developmental Disabilities. Those are community residences. They are much smaller than nursing homes, and yet they are dealing with individuals with significant health issues. Comorbidities is the term would be used in terms of reference to COVID-19. And so that's a primary part of our recommendation. We recommend further use of home care. Home care should not be a begrudging part of the system, something that the state and the federal government finance, but they wish they did not. Home care is something that people want and something that people can use and something that's been successful. We saw in COVID-19 that there simply were fewer deaths with COVID-19 in home care and in systems like the OPWDD system. And the reasons for that was there was a lack of concentration of individuals. But we also saw that the numbers of people in nursing homes dropped. Nursing homes before the epidemic had a occupancy rate of north of 95%. That had dropped by the time we completed our report to below 85%. That would suggest 2 things. One very important one for us, which is the public doesn't want to see themselves or their loved ones in nursing homes. So let's rethink this. Let's figure out a better system. There'll still be a role for nursing homes. They'll still be important, but we want to see a lessening of their use. Another recommendation that we made, and this is something we actually heard from nursing home representatives themselves, is let's take the opportunity now that there is openings in nursing homes, now that there's vacancies, to weed out the bad actors. That's been a significant issue. You couldn't weed out bad actors when there was no place to put individuals in need of care. Now there is room. Let's take the opportunity to do that. Those are really central to our recommendations. Our other recommendations are more specific, more focused on very specific instances within nursing homes. We call for further review of the regulatory standards. We call for improvement in the survey process. For those of you outside of healthcare, that means the inspection process that goes forward. The inspection processes always tend to look at the trees. We'd like the inspection process to be focused more on the forest. We want to see better preparations for emergencies. That's something that was highlighted throughout this report, throughout the pandemic. We want to see more support for staffing in terms of more individuals, more training, probably better pay as we, what will it take to have sufficient staff within the long-term care system? And the long-term care system, even before COVID-19, was desperately in need of staff. We want to see a closer review on the limits on visitation, which was also extremely important. And something is still going on right now. In fact, Nursing homes and other congregate care settings, even today, have significant limitations on visitation. And we think time has come to review that. In fact, we completed a report a month ago, 2 months ago. The time has come to review those limitations on visitation and see if these doors can't be reopened. Because it's, this is more than just deaths. It's also the real loss of community, real loss of contact. We'd like to see better and clearer guidance. Now, we recognize the beginning of the pandemic, especially when things were simply in a confused state, and everyone in healthcare was literally drinking from a fire hose, as there was so much in the way of new recommendations, new guidance, new regulations, often conflicting, that needed to be addressed. It created issues. We want to see infection control officers be further empowered, probably making them direct reports to board of directors. We want to see the collection and dissemination information, right? You can't analyze a problem without actually having the information available to you to see what has occurred. And then we want to see a proper allocation of resources. We saw especially at the beginning of the pandemic, long-term care's needs came behind hospitals. Now, obviously, when there wasn't enough to go around, hard decisions had to be made. But those hard decisions were being made at the expense of long-term care and put residents of long-term care at risk. So those are our recommendations. Sandra, will put it back to you.
Sure, and actually, I think one recommendation that everyone had agreed upon was that that in healthcare, let's leave the decisions to the healthcare professionals. Let's take politics out of the healthcare decisions, and that was from federal level, state level, local level, everyone. I think everyone agreed. It was unfortunate. Yes, this was a pandemic that hadn't happened in 100 years, but that was something that I think everyone had agreed upon. So those are our recommendations.
Thank you very much. At its meeting yesterday, the executive committee endorsed the report and recommendations of the task force. May I have a motion to approve?
Second.
Having a motion and a second, I now open the floor for discussion. I would first like to recognize Joseph Rani. Mr. Rani, if you can turn on your, there you are. Hello.
Yes. Good morning, Joe Rani. I'm co-chair of the Disability Rights Committee, but I speak on my own behalf. First and foremost, to the leadership for taking such aggressive action in creating the task force. Co-chairman Fernandez and co-chairman Rivera did a great job, particularly relating to diversity and inclusion of Sheila Shea and Sim Goldman and Mary Morrissey from the Disability Rights Committee. Just tremendous work. Very pleasing as well, if I could mention, concerning the policing report and recognizing the needs relative to people with disabilities, and Judge Shankman relating to the bar exam. Truly appreciate considering disabilities. The report prepared by the task force really lays out very comprehensively and collaboratively the problems that we all faced. In the disabilities community, obviously, we share all the issues relating to older persons as well. You'll see at page 779 with my comment, a proposal relating to accommodative housing to address the issues relating to senior housing as well as accommodative housing for people with disabilities. It will provide an appropriate living environment, appropriate service delivery, preservation of assets through the community Medicaid exemption, as well as a person living with their spouse, and because of the small economies of scale relating to these small residences, Medicaid expense reductions and savings through appropriate community delivery, all the things that the task force addressed. And so appreciative that we look now towards community-based housing. The proposal is a collaborative effort, and I have to thank the association. The task force moved through all the formalities in coming forward with a report that's excellent. The proposal came up through a different course in grassroots, through our membership and collaboration. and really cooperation between members of the health laws section, elder and special needs section, disability rights, and many others, and many outside through the independent living organizations as well. And this collaboration came up really just through people looking at what we have and how could it be different. Not looking at positions, but looking at how we can provide a critical analysis to solve the problem. I believe the proposal provides an option for us to pursue it. I think as an organization, we can put together a condo plan, a template, so that these could be in every small rural or urban area. And that we could look at the licensing issues and develop the conversation so we have a solution. The task force in this report went a long way towards identifying the different issues and the unity in how we address issues. And it is a real privilege to be part of this association. It's a real privilege to have collaborated with everybody. And Hermes, thank you very much for that first phone call that you really connected me with being able to participate. This association is the greatest I've ever belonged to. Thank you very much.
Thank you, Mr. Rani. I'll now recognize past President Kate Madigan.
Thank you, Madam Chair. As a longtime practitioner in elder law as well as special needs planning, I applaud the work that you have done here, both Sandra and Hermes and your incredible committee. But I do have a question about what are the proposals to pay for this priority that has been actually a priority of the State Department of Health for some time, that we need to reduce our dependence upon nursing home care and focus on community-based services and home care, which right now is far more expensive than nursing home care. So in my community, which has a very high aging population and more community-based services in most counties in the entire state, Broome County, we struggle to provide home care for our middle income and low income clients. The state has gone yeoman service in terms of providing Medicaid for assisted living and moving more people out of nursing 24/7 nursing home care and assisted living. But we still have far too many individuals who, but for the lack of 3 to 5 hours a day or less of home care, find themselves in assisted living or nursing home care due to the cost. And the counties can't continue to subsidize Medicaid to the extent that it has. So I'd appreciate just some insight about the conversations that the task force had about the fiscal realities of shifting the system, as we would all like to see, to home-based care. Because let's face it, no one wants to die in a nursing home bed or a hospital bed. We all want to die a good death in our own homes. Thank you.
Thank you. Sandra,
Hermes, did you want to?
Well, Kate, you've placed quite a bit into that question. We did have some discussions on that. Truthfully, we did not focus to a great deal in terms of the costs. I don't know that I agree with you, though, that the costs are greater in a community-based system than they would be on a nursing home-based system. Certainly, there are those individuals who, if they receive 24 hours a day of home care, may be more expensive than nursing home care. But I don't want to get too far into the weeds on this, but the way the Medicaid system is structured, the state and the waiver system that the state has been utilizing successfully with the federal government, right? Individuals have to be receiving care at or below the cost of nursing home care in order to fit within one of the waivers. So I apologize to the rest of the room for getting deep into the weeds there, but there are some issues. The other thing I would point out is we didn't simply talk about home care. We also talked about a community-based system, which we do see for people with developmental disabilities, and we do see for people with mental health issues. And that is an expensive system. There's no question that's an expensive system, but so is nursing home care an expensive system. And actually, Joe Rani said this very well in his written comments. What we really are calling for is let's discuss deinstitutionalizing elder care, because the elderly are the last segment of society in which it's acceptable to provide their health care in an institutional setting as opposed to community settings. And we think that we didn't call for this to happen overnight. We called for this to be a transition, and we think there's opportunities there to make this real.
The only comment I would have to that about the 24/7 care is that in large swaths of, especially upstate New York, we don't have the labor pool to provide 24/7 care through the Medicaid program. It's just not possible. So my clients and I have one of the largest elder law groups in upstate New York, Hermes, and we have a full-time nurse care coordinator and a full-time Medicaid specialist. And I have to tell you that yes, indeed, if you need any more than 3 or 4 hours of home care every day, our middle income families cannot afford it. That's the problem.
Agreed.
So I'm glad to see you. I'm glad to see you moving in this direction. And I hope that everyone will support the report, because we have to start moving towards community-based services along the lines, as you note, for our disabled and developmentally disabled and other less abled individuals in our communities. So thank you for taking a strong stance on that.
Yeah, and
Thank you, Past President Madigan. I'm going to now call upon Past President Michael Getnick. We don't see you or hear you. Oh, there you are. If you just unmute yourself.
This is more of a question at this point, Hermes. When this report is done, is your task force going away, or is this task force still going to deal with continuing problems with long-term care? And I have a question, but that's what I would like to know first.
That's Mike, that's not our call. Sandra and I both, I think, understand our charge to be completed with the delivery of this report today.
The reason why I raised that is that we're talking about costs and doing things, but I don't hear the discussion about people who have long-term care insurance, who have been advised that at some time in their life that this would be a good thing to have by their financial planners or estate planners, et cetera. But what's happening, and this happened even before the COVID situation, is the companies that provide this, and it's expensive, the premiums. The premiums, the younger you are and the healthier you are when you first start the policy, the less your premium. But they're just allowed by the state of New York now, when they have increases, they're not talking about a $100 increase or a 5% increase. They're increasing the premiums like 20, 30% a time, year after year. And it seems like the state goes along with this. And I have clients who are calling up and saying, what's going on here? Because we can no longer afford to have this. And the options we're given is we can pay the same premium, but get far less coverage than we had before, or we can stop. And these companies have had the opportunity of getting all these premiums when these people are healthy, banking them, and now basically telling them you can go away. Has that even been considered? I don't know if that was within the charge of your force, and I realize it involves more than just your force. It would involve the health law department, insurance, et cetera. But has anybody thought about that? And I don't know if anybody in the House of Delegates has experienced this or not, but the premium increases are outrageous and are all approved by the insurance department of the state.
That is not something we discussed, nor did we think it was within our scope.
Thank you very much. I will now call upon Paula Engel.
Thank you, Madam Chair. Paula Engel. I'm with the 5th District Delegates, but I'm speaking from my personal experience as a human services attorney in the government field who works in the area of Medicaid, special needs, and people being served by OPWDD. It is something I've said before this body before, which is that it is not useful, in my personal opinion, to make recommendations without having a full discussion about the cost implications, especially when you're talking about Medicaid. And it's easy to forget given the past year that we've been through with the pandemic, but what we were looking at before the pandemic was a significant budget deficit directly related to Medicaid. And prior to our discovering and being, learning about that budget hole, we had been the target of a congressional report that specifically looked at the huge escalating costs of home-based care as the part of the Medicaid department that, as far as the congressional reporters were concerned, did not significantly or adequately in New York State address the area of fraud, waste, and abuse. And unfortunately, my personal practice experience on behalf of governments, that is one of the areas, home-based care, that is unfortunately pretty rife with fraud, waste, and abuse. At the same time, I completely support the efforts of the task force and agree that it's not only the right thing to do to deinstitutionalize elderly and people with special needs who do not need that level of care, but it's also the constitutional requirement as set forth by the Supreme Court in its decision in Olmstead. The question is, how do we effectively deliver that? And I think as lawyers, we are also responsible to the community to make sure that we're making recommendations that are not cost prohibitive. And one of the models that I wonder, and I'm asking the authors of the report to address, is whether you dove into the model of family type homes for adults, which are a model that is kind of roughly equivalent to foster care provider homes for those individuals who could remain in the community, but need some level of supervision and support. Right now, the model doesn't work because they are not able to leverage the SNAP benefits of the residents they're supporting, and they have to have a complete separate source of income, which is sort of equivalent to foster care providers. But I wondered if you did, in fact, address some other models other than just home-based care in the consumer-directed program.
The answer is yes. We did. We looked at other models. In fact, there's some reference in the report, although we didn't call it family-based care. The family-based care is available in the OPWDD system at the Office for People with Developmental Disabilities. And we also reference in the report that before nursing homes became dominant, really in it, around the same time that Medicare was put in place, much elder care was actually provided through family sorts of structures, almost akin to boarding homes, right? There were adult homes that were essentially an individual who had space in their homes and made them available to individuals. Now, those homes would not meet most needs today because most of the needs that are paid for are much more medically based. So that's why we're looking at other things, looking at where other people who have very great healthcare needs are being cared for outside of the nursing home system.
Thank you very much.
Okay.
Thank you very much. At this time, I'm going to call for a vote. As you all know, the poll will appear on your screen. Please choose your vote, submit it. We will let it sit for 30 seconds and then provide you with the results. The motion to approve the task force report has passed. Thank you very much for your presentation.
Thank you.
Thank you.
Okay, thank you. We will now move to item 12 on the agenda. We will return to item 10 when I have more information for you. But at this point, we will move to item 12 on the agenda, the report of the task force on the uniform rules. This is not an action item. This is an informational report being presented by Mr. Richard C. Lewis and past President Sharon Gersman. Just give us a moment to bring them up on the screen.
Are you ready?
We are just there. You guys are. Now we see you and I hope everybody else can see you. It looks that way from my end.
Hi, Sharon. Thank you, Madam Chairwoman. We're here today just to give an update with regard to what's gone on with the uniform rules and how it's impacting our profession since the time of our last meeting. Right after our meeting with the House of Delegates on the 10th of April, then President Scott Carson met virtually with Judge Marks and received some very optimistic input that our proposal to pause the implementation of the rules, albeit for 60 days and not a year, was a reasonable ask. And we were very optimistic that this was going to happen. Without going through all of the various steps between then and now, our optimism was squelched when at the end of May, the administrative board met and they indicated that they were not going to give us a stay or as they call it, a pause. However, what they did say to us was that they would like to see what we were going to present to them, and they, quote, stand ready to make changes where appropriate. End quote. We are acting in good faith. We are acting with a sense of urgency with regard to this, what we believe to be an extremely important issue. And we are assuming that they are also going to act in good faith. And we're hopeful that we are going to be able to talk to them very soon. We're hopeful that members of our committee are going to be able to meet with the presiding justices. We are hopeful that President Brown is going to have an opportunity to meet with the chief judge, and that we can try to move our concerns along and hopefully confront the difficulties that have been raised in connection with the application of these rules. In any event, we have filed a preliminary report, and that preliminary report will be added to significantly over the course of the next few weeks and months, hopefully weeks. And we hope that we can provide that to the judges for their review. We've provided a copy to Andrew. We've filed it with the reports committee, and we really encourage you to take a look at it. I think it'll give you a pretty good flavor as to where things stand. Now, right after our House of Delegates meeting in the spring, Scott appointed this Uniform Rules Committee, which I'm chairing. And I can't tell you how honored I am to work with not only great lawyers, but very bright people: Vince Doyle, Sharon Stern-Gersman, Jim Kelly, Peggy Lynch, and Mike Getnick, all of whom know how the courts work, know how to handle cases, and understand the impact of these rules on practice. They know what they're doing. We've met a minimum of one time a week, usually more, since we've been appointed. We've solicited all of the sections for their input. We've gotten input from local bar associations and various other organizations, as well as individuals. As far as the membership goes, we ran an unprecedented 4 two-hour information gathering sessions with the membership. I know that Scott was there for part of it. I think Andrew was there for a portion of it. We had over 400 people sign up, and a large number of these people spoke. These lawyers were a cross-section of our profession. We had people from urban areas and rural areas. We had large firms represented, as well as small firms and sole practitioners. We had judges and court personnel there, and people from every discipline. And perhaps as important as anything else, we had many pro bono providers, as well as legal services lawyers. The overall flavor of the input that we got from this is in our preliminary report. But basically it was that these rules are superfluous in many instances, inapplicable to many areas of law, and most important, it's going to increase by a significant amount the work that is going to be required of attorneys, and it's going to increase the expenses that are going to have to be borne by attorneys. It's also going to, even more importantly, perhaps, increase the expenses of bringing a lawsuit, which is going to completely work to the disadvantage of a large part of the population. The costs are growing. When this happens, it's going to not only interfere with our ability to practice law, especially small practitioners, both urban and rural, but it's also going to deny access to justice to a larger percentage of our citizenry. We've already got a system that's very highly criticized. There's the haves and there's the have-nots. The haves have access to justice. The have-nots do not. Well, the have-nots are going to get bigger. And that's one of the problems that we have with what's going on here. We got a lot of input from people who said, look, I'm not going to be able to do pro bono work anymore. I'm not going to be able to take a $30,000 case anymore. The middle class is starting to lose its access. It's continuing to lose its access to the courts. We ran a survey, and that survey is set forth in the preliminary report. And there were about 150 people who responded. And these are some of the observations. Of those surveyed, 2/3 felt that this was going to have a negative impact on the practice of law. A full 86% felt that the costs were going to increase. 71% outright opposed the implementation of these rules, and 76% believed that this will have a negative impact on access to justice. The problems for lawyers are especially burdensome when it comes to the small practitioner, who's not going to have the time nor the financial resources to keep up with these rules. And with regard to rural practitioners, and by the way, I direct your attention to the Rural Justice Task Force report that was approved by this body in April of 2020, and both Sharon and I were members of that task force. You're going to see the heavy burden that it's going to put on the entire justice system in the rural areas of our state. Essentially, the situation is that you can't have a one-size-fits-all type of rules. There's so many things that have to be worked out with this, and we are very anxious, and our committee has a serious sense of urgency with regard to getting this before the courts so that this can be more applicable to the practice of law. With that, I'd like to turn this over to Sharon, who wants to highlight some of the things that we are concerned about.
Thank you, Dick, and thank you for your leadership in this task force. I wanted to just briefly highlight 4 of the rules. There were a total of 29 rules that were adopted on effective February 1. And we do address all of these rules in our preliminary report. And I encourage you, if you haven't yet looked at them, to do so. The 2 rules that we heard most criticism of were first, the summary judgment rule. That is a requirement that every movement for summary judgment submit a statement of undisputed fact, and that every opponent address each and every fact that is set forth in the statement, also citing chapter and verse of where in the answering papers those are addressed. Aside from the amount of work and the sheer cost that this adds, one thing that is very important to note is the difference on this rule from the way it is set forth in the commercial division rules. In the commercial division rules, this requirement is limited to those cases where the judge has specifically ordered it because the judge feels it's appropriate and would be a positive addition to the summary judgment motion. This rule applies it to every single summary judgment motion in every kind of case, which means that there are a whole bunch of areas where it is creates all kinds of problems that we set forth in the preliminary report. For example, what if you were opposing the summary judgment motion on timeliness issues? What if you're opposing it on the failure of the movement to meet its burden before it triggers your burden to answer? What if you're opposing it on grounds of 3212F, that the information is solely in the control of the movement and you haven't had adequate opportunity to discover it? What if your issues with the list are materiality? What if you're dealing with expert opinions? To what extent are you supposed to, as an attorney, rewrite those expert opinions into statements of law? Think about physical injuries. Again, to what extent are you supposed to write out each and every physical injury as a statement of undisputed fact? And finally, the effect of an inadvertence of failure to address one or more of the facts, even though those facts may be in fact addressed in the affidavits and other evidence that you have put forth. And the opportunity that all of this presents for gamesmanship. We've set forth those in the report and commend them to you to read about it, to think about all the different problems that this rule presents. The second area we heard a lot of comments on had to do with length of depositions. Depositions under the rules are limited to 7 hours, regardless of the type of case and regardless of how many defendants or how many parties might be sharing that 7 hours. There is no mechanism for accepting, for example, medical malpractice cases that often involve much longer depositions because there's so many parties and so many different interests that are being expressed. And it puts the onus on the party who needs a longer deposition to actually formally make a motion before the court to have that addressed. We think there are better ways to handle this, leaving it in greater discretion of the court and not requiring someone to actually have to make a motion to get permission to, in essence, do their jobs and represent their clients. There are two areas that you might not be aware that present a terrible problem for practice across the board. One of them is the requirement that every item that is given in discovery be verified. Now, that might make sense in a commercial part where you're dealing with corporations and you don't really know where it comes from. But think about when you're dealing with a simple automobile accident, or you're dealing with a matrimonial, needing to go back to the party. And it may not even be the party that technically provides on behalf of a defendant or a plaintiff the documents, but to have to go back to a party and get each and every one of those documents verified adds a level of complexity and annoyance that just is not does not promote the efficient disposition of the case. And finally, the last one is the area that in a trial, a court, a non-jury trial, the court may order that certain testimony be by deposition. Now, we can recognize that there might be some situations where this is positive, but the way the rule is written is that the court makes the decision with no input required from the parties. So you may find that where you want to bring a witness in to testify in person, that you are now required to provide that testimony by affidavit. And it of course affects the other party in order to cross-examine. The right of cross-examination has been taken away. And we think that this rule also sort of underscores one of the flavor of a lot of these rules, and that is that it says that the court knows best, not the lawyers who have been living these cases day in and day out. And that's, we think, problematic with many of the other rules that we've set forth. So between now and when we do a final report, one of the things that we will be doing is producing a red line of some of these rules and making changes that may reflect either, in some cases, elimination of the rule altogether, but in other cases, limitations with respect to the types of cases that it involves with and the situations where it may not be appropriate to have the rules. And we do look forward to your input, and we look forward to sections weighing in. We are particularly interested in hearing from the family law section because we know that many of these rules are in direct disagreement with some of the rules with respect to matrimonial actions. And with that, I invite any comments and questions.
Thank you. Thank you very much for your report. I'd like to add before we open the floor for questions that this report was given to the executive committee yesterday. It was accepted with the thanks of the committee. President Brown has already reached out to OCA and a meeting has been scheduled for later this month to discuss this issue. I thank the task force for their work in this regard.
Sherry, can I say one last thing? There.
Oh, yes, sorry, my mic was off. You may.
Sherry, can I, if I can just say.
Yes, I'm recognizing you.
Thank you. Two quick things. I want to reiterate what Sharon said. We are looking for more comment. We've set a cutoff date of July 1 because time is of the essence. We want to start putting together the remainder of this report, the final report. We appreciate that President Brown is going to be meeting very quickly, and he and I just spoke a couple of days ago about this. So Andrew, thank you very much. The last thing I want to say is what we're talking about here has nothing to do with the implementation or the use of these rules in the commercial courts. They work well there from what my understanding is. We're talking about the other areas of law that many of us practice in. And so with that having been said, we'd love to hear from anybody.
Thank you. So I would like to remind the House that we still do have one more action item that we need to get to after this report. And this report is an informational report and we are running behind schedule. So please, if you have comments, remember this is an informational report. You will have additional time to comment at a later date. I now will recognize Steve Richmond.
Thank you, Madam Chair. Richard, Sharon, this was an outstanding report. Richard, thank you for bringing this to everybody's attention last meeting. I am disappointed that we're not just getting this preliminary report out. You clearly identified that this is adversely affecting practitioners and litigants across the state, upstate and downstate, suburban, rural, urban, communities of color, pro bono representation. If we ever had a coalition to get together that represents the whole state and get action, this is a ready-made coalition. And you also point out, which I don't know if everybody read it in the report, that some of the rules are contrary to the CPLR, the statutory provisions. The court system just ignored the law. So my question, I don't know if it's to you, Richard, or more to the president and the others. We just heard about the need to help the media and get the news out. Why don't we get this out all over the state and get the public attention to it? Maybe it'll get OCA off their you-know-whats and actually be responsive, because this rule remains in effect. And the fact is that after year, when we support them in their effort, when we've raised an issue and we only ask for a pause, not repeal at this point, they gave a straight no. So Richard, thank you for your work, but I don't know if we can afford to wait till we get back together into the fall. So I asked the president and to ask why we can't at least release the preliminary report and get some publicity out on there without taking other action. Let this get out to the public and get the public to react.
I think that the intent is to release the preliminary report with the caveat that it's only the position of the committee and not the position of the association until voted on by the House of Delegates or the executive committee. One of the reasons we did not want action today is that we initially, in our perhaps over optimism, thought we would have the time until July 1 to solicit comments from sections and committees. And we think, in fairness to our sections and committees, we should honor that time frame and allow them the time, especially because the difficulty in the summer, to put together their comments so that they can be incorporated into the final report. But I think that the intent, when President Brown meets with the chief judge, and he's already delivered this as a preliminary report with the caveat on it that it's the position of the committee. I think the idea is to try to move forward if possible.
Thank you. I would now like to recognize Oren Cohen.
Thank you, Madam Chair. Sharon, Richard, thank you so much. This is a major concern from all the small practitioners in my district, myself, and we're all very concerned, and the expeditious need to have this done and changed is so evident. I will take your report and give it out to my local bar. I will ask them to send out to the membership for comment and hope to get things back for you in time, because any way I could help, what you're doing is excellent. I truly appreciate it, and thank you so much.
Thank you.
Thank you. I would now like to recognize past President Bob Haig. I just elevated you, Bob. Sorry about that.
Don't take it back. Can
Getting
you hear me?
into the meeting, but I'll recognize Mr. Haig.
Can you hear me okay?
Yes.
Okay. Bob Haig, a delegate from the New York County Lawyers Association, though I'm not speaking on behalf of NYCLA. And I should say, in the interest of full disclosure, I am the chair of the Commercial Division Advisory Council, which promulgated or recommended a lot of these rules, although that was only for the commercial division. The Advisory Council has not been involved in recommending, lobbying in the general issue of exportation to other parts of the court system. We only focus on the commercial division. There are some facts, though, that may be relevant to your consideration of this, which were not before the House in April. And that is, over the last 8 years, there have been literally hundreds of New York lawyers that have devoted many thousands and thousands of hours to trying to attract and retain businesses in New York State. And those efforts have been intended to benefit all of the state of New York and all of its citizens, but a substantial component of that effort has to bring legal business to the state of New York. More cases, more money to benefit lawyers economically. And that has included things like the well-known commercial division movie, which has been sent by email to 280,000 lawyers, encouraging all of them to distribute it to their potential and actual clients. It's encouraged outreach to every English-speaking and some non-English-speaking bar associations in the world. It's outreach to 1,200 chief legal officers of major corporations, and those efforts are ongoing. And the results of that, we don't have time to talk about it, but the city council in New York City, an organization that most of us don't think of first when we think of business friendly, came up with a formal proclamation, which it drafted, not us, a little while ago, saying, quote, New York owes most of its world-class status as an economic engine to its world-class court, the commercial division of the New York Supreme Court. And I mention this because the centerpiece of a lot of these efforts have been the rules that are in the commercial division. Now, I listened carefully to Dick Lewis's comment, which I appreciate, that this is not an attack on the commercial division. I understand that there are parts of the report that might have the effect of undermining it. I think that's something that the committee needs to address. These rules were intended to be client-friendly. That has always been a purpose of it. One of the major efforts that has been made, incidentally, is the
Mr. Haig, I'd ask you to please wrap up your comments.
There are a lot of lawyers who are trying very hard to achieve these economic benefits. And I think that the State Bar Association should make every effort possible to support those efforts, to enhance those efforts and to take great care not to in any way undermine them. Thank you very much for the time.
Thank you. Do we have
I
any brief response from the
briefly respond?
presenters?
Yes,
Yeah.
yes. So I understand concern with respect to in looking at proposed conflicts between the existing commercial division rules that were then imported and the CPLR. And I certainly and your opinions with respect to that, and to the extent that you would like to provide us any material to the contrary, we're perfectly happy to accept it and look at it and incorporate it. But with all due respect to the commercial division rules and the fact they may be accepted by the people who are in the commercial division and are commercial litigators day in and day out, we think it is, if to the extent that these go beyond the CPLR or they are in conflict with the CPLR, it's a real problem for people who are either not everyday litigators but have some matters before the court. And it is a real problem for those who may be licensed but are practicing primarily out of the state, to be able to then determine whether or not there is a true conflict or simply a potential conflict, to then look at the case law to decide which one, whether this has been resolved, because the CPLR rules, not a rule of the chief administrator, and we think that this continues to be problematic for practitioners. And so we think it's an important point to address. And but again, if you think some of those provisions may be in error, if you think some of the paragraphs or some of the statements may be in error, we certainly invite you to submit any case law to the contrary, and we'd be happy to review it and incorporate it into the final report.
Thank you. I'm going to, for the last, recognize on this issue, past President Michael Getnick. He is a past president.
I think I'm unmuted now.
We can hear you.
I think this is really a crucial time, and I look forward to Andrew's meeting with the chief judge. And the reason why I say that is we thought there was going to be a moratorium, and information was given to us that there would be, and that was passed along to the membership. And then what I consider a very curt letter is written to say, no, there's no moratorium. Well, that can be reversed too. And I think this is the time for the chief judge and the OCA to show some respect for the Bar Association, and that they have nothing to lose by allowing a moratorium for a period of time that's reasonable. And if they don't do a moratorium, all of our lawyers in the state have a lot to lose for all the reasons that have been well brought out by, they've been brought out by Richard and Sharon. And I think most of us understand that. And I think a message has to be given to the chief judge that if this is to be a working cooperation, they should put that moratorium into effect so we can further address these matters. That's all we're asking for at this point. And I think if they can't come back with that response, then the handwriting is on the wall of a lack of respect for the importance of the Bar Association. And so I think this is crucial. Thank you.
Thank you very much. At this time, your report is accepted with thanks. Oh, sorry. Our President Brown, would like to comment.
I would. First, I just want to say thank you to you, Dick, and Sharon and Jim, and others who worked on your committee. I understand the urgency and the importance of this matter. Dick, you and I have had a number of conversations after the committee was formed. You provided me with the preliminary report and even aspects of it while that was in the works, and I thank you for that. Even before I had the opportunity to review the preliminary report in full and digest it, I did reach out to the Chief Judge and requested a meeting that has been set. I will be meeting with the Chief Judge and Judge Marks in just within the next 2 weeks. And I will certainly discuss this with them and impress upon them the good work of this committee and the importance to so many of our members. I will note that past President Carson did have personal conversation with Judge Marks and received a letter recently. And Judge Marks did indicate that he was willing to consider comments and thoughts shared from NYSBA and take those into consideration, even though there was not a moratorium. And so I do thank past President Carson for being able to navigate us to that point. I will now take up the effort and meet with the Chief Judge and meet with Judge Marks and hopefully get some direction as to how we move forward with the concerns of so many members. And I will be reporting back to the committee. And again, I want to thank all of you who have worked so hard and so quickly to bring us to where we are now to keep this matter alive in the interest of so many of our members, not only in the Bar Association, but those across the state who do the good work on behalf of so many clients. Thank you.
Thank you, Andrew.
Thank you, President Brown. Thank you to everybody. We are now going to turn to agenda item number 10, which we had skipped over earlier. I'm going to reintroduce the agenda item for framing. The next report on our agenda is from the Committee on Standards on Attorney Conduct. The committee is presenting a report recommending the amendment of Rule 8.4G of the Rules of Professional Conduct. The comment period for this rule ends at the end of next week. The report will be presented by committee member Professor Ellen Yarashevsky and consultant Deborah Raskin. As Ms. Raskin is not a member of the Committee on Standards of Attorney Conduct, I am extending her the privileges of the House to speak. Thank you.
Thank you very much. And thank you all for your consideration of our report to change Rule of Professional Conduct 8.4G to address discrimination and harassment. And first, my apologies for the delay in this presentation, but we were given a later time slot. I also want to thank Deborah Raskin. We have worked for 4 years in COSAC to develop a proposal, and Deborah has been instrumental with her expert knowledge in employment law in assisting us as we navigated through a rule that we believe is an excellent compromise. As you know, New York has a current rule, but very few seem content with our rule. And one of the primary reasons is that the rule does not address harassment at all. We noted a number of reports in our COSAC report from the 2020 New York State Commission on Women in the Courts, lengthy diversity committee reports, all of which acknowledge that harassment is a particular problem within the legal profession, as is discrimination. And we believe it incumbent upon ourselves to develop a report and a rule that would address harassment. Secondly, the New York rule only deals with inside law firms. It does not deal with sanctioning conduct, for instance, in depositions, with court reporters, or in professional activities. And significantly, it mandates exhaustion requirement. One has to complain to a tribunal before filing a disciplinary complaint. So even the courts seem unhappy with the current rule. We were caught by surprise in COSAC when in mid-March, OCA issued a request for comment to the bar about the ABA model rule. That rule is much broader than our rule. It has been declared unconstitutional, at least in one state. It has not been adopted in a number of other states. And as I will explain later on, we do not believe that we should adopt that rule in New York. The courts have given a deadline of June 18th to comment, and we believe the courts are intent on adopting a new version of Rule 8.4G. And so it is our suggestion here that if the state bar wants to weigh in, that our proposal should be seriously considered and adopted. We sent out our report for comments, and we got a remarkable number of comments. This is quite a controversial rule. We got 15 entities, national organizations, professors who commented. And the comments were quite disparate. They were divergent. There were many who said that we went too far, that their First Amendment concerns, that there was viewpoint discrimination that would chill speech, and others that said our proposal does not go far enough. We believe the compromise that we've developed is a compromise. It doesn't deal with every concern that people have. We believe, however, that it's fair to lawyers. It gives lawyers adequate notice, and it stands a much better chance than the ABA rule of passing constitutional muster. We don't think it's perfect, but we think it's quite good. And I will say that nationally, we've received very positive feedback about our proposal. The Pennsylvania bar looked at a rule similar to the ABA model rule. They declared it to be unconstitutional, that it was viewpoint discrimination. The bar in Pennsylvania initially decided that they would appeal that ruling, but then they dropped the appeal. And so they are now back to a reconsideration of their rule. Colorado just adopted and upheld a narrower version of a rule than the ABA rule, and they criticized that ABA rule. So with that background in mind, what I'd like to do in just a few minutes, actually, is to go through what I think are the more controversial pieces of our rule and discuss each of those, right? So the most controversial part, of course, is adopting a rule specifically on harassment. One of the questions is, how far do we go in sanctionable conduct? There were numbers of people who thought that we should sanction conduct that could be a teachable moment that wasn't severe. For instance, a man puts his hand on a woman's back as he escorts her. She's uncomfortable. She considers that unwelcome physical conduct. It is a teachable moment. We believe that might be a teachable moment, and that's what it should be used for within firms, within the bar, to teach people why that's inappropriate, but it should not subject a lawyer to sanction. We wanted to ensure that our harassment rule was not vague or overbroad. We didn't just want to say unwelcome verbal or physical conduct. So we limited it to severe or pervasive misconduct. Severe or pervasive, derogatory or demeaning conduct, or unwelcome physical conduct. We made it clear that it had to be directed at a person or persons. This is specifically to avoid the problem that was raised in Pennsylvania, where the plaintiff said at CLE presentations or teaching, if one takes a controversial position, they did not want to be accused of harassment. We want to ensure that that is not sanctionable conduct. So we made clear that it's not at a CLE program or in teaching. We also made clear that there's not a concern in the lawyer accepting or declining cases or in advice, assistance, or any advocacy to a client. With respect to the terminology of severe and pervasive, we decided to use that because there is a body of law, primarily from Title VII, that guides the definition. And so severe may be a single incident. For instance, the use of loathsome words such as the N-word or the C-word is severe, and the courts have recognized that. Verbal conduct that could be a severe discriminatory tirade that poisons an atmosphere, that's also severe. Pervasive in the law, it's more than episodic. There's no magic number of incidents, but pervasive can be several incidents. We also included a provision defining the practice of law to ensure that it went beyond the law firm, and it included conduct at professional activities. A great deal of the commentary, particularly from women, about harassing conduct was when it occurred at professional activities. We also have a provision for the beginning is unlawful discrimination. And the reason that we have unlawful discrimination and not just discrimination is one, that the law in New York, the New York human rights law adopted in 2019, is very broad. It covers employment, it covers housing and public accommodations, but for our purposes, it covers within the employment context. And within that, it's discrimination against people in a wide range of categories. And it also includes harassment within the law firm, and it does not have to be severe or pervasive within the law firm. And so we believe that that was sufficiently broad that it would cover a wide range of conduct. And so those are our basic provisions. I will stop there because I think that people may have a number of questions. If there are significant questions regarding employment practice or employment law, I may turn to Deborah Raskin to answer those. So thank you very much. And I appreciate your questions and comments.
Thank you for your presentation. In just a moment, I will call on people who have raised their hands. First, I'd like to recognize past President Sharon Stern-Gersman. Sharon, you're on mute, but we can see you. There
I'm
you go.
sorry, I was in the process of shifting over when you must have called on me, so I wasn't sure that I was recognized. First of all, I'd like to thank COSAC for this report. You've gone a long way toward fixing a lot of the problems of the ABA Model Rule 8G, and I really appreciate the threading the needle that you had to do even to get this far. I have two concerns remaining with respect to this that I hope that you can address in some positive way. One is you've already mentioned severe or pervasive, and for those in the employment area, maybe you understand what severe and pervasive is. I'm not sure the rest of us necessarily are as familiar with it, and now it would apply to all of us. And there's surely, if I look at the comments, there's a really, really big difference between a petty slight and what may be severe and pervasive comment. And it might be helpful in the comment, at least, to give some indication of where that line might be drawn, either through examples as you gave just now in your presentation, or at least a little bit more fleshing out of the definition, just so that there's guidance to attorneys with respect to their behavior. The second issue I have has to do with something that may be near and dear to many of us, and that is the inclusion of what are called bar association activities or events. And I'm thinking about things like happy hours that a bar association might have at a bar that doesn't necessarily have a program. It doesn't really necessarily relate to issues that bar associations are putting forward. People might attend them not really understanding that that's part of the practice of law. Alcohol is involved, and people's judgment sometimes wanes, and that doesn't necessarily forgive bad behavior. But I wonder if you might be willing to change activities or events to the word programs, where I think that might be a little bit more formalistic, and it would take away from that happy hour model. And I apologize for not submitting these much further in advance. I sort of had my hands full with the uniform rules. So again, my apologies and thanks for your work on this.
Would you like me to answer them as we go along?
Yes,
So,
please.
first of all, Sharon, thank you so much for your comments, and there's no need to apologize. With respect to your last comment, I would consider that absolutely a friendly amendment. Our intent in including professional activities as within the definition of law was precisely to address the concerns that you raised. So if it's not clear that professional activities includes bar association events, it should be. If you believe that programs or events covers that, I would consider that a friendly amendment.
Just to be clear, I think that including activities or events goes too far. I don't think that in the context of that random happy hour that lawyers understand that their behavior may be subject to discipline. And I'm not so sure that it's fair to them to do so. And so my suggestion to substitute programs for activities or events is to take away the happy hour situation from being under the rule.
Oh, I thought you were arguing the opposite. I will tell you that many of the comments we got, particularly from women, was about those happy hour programs and that they wanted those included, which is why we have professional activities.
Ellen, if I can say something, may I say something with regard to the law? I mean, there is a significant body of case law that deals with employers' off-site activities and the application of anti-harassment laws to those activities, with the recognition or the policy purpose that that's where connections are made, that's where people get ideas, that's where people are able to get ahead in many different ways. It's why we join bar associations in the first place. So it is important, since that's such a critical part of a lawyer's professional and personal life, that that be encompassed. And there is, for better or worse, a body of law on that again, to some extent defines what severe and pervasive is in those more casual contexts. And it's not just the high hand on the shoulder or, you know, you look great in red kind of thing. I mean, it is generally in the case law more significant than that. So I don't think there's going to be a real possibility for people to be ambushed by those expectations.
So thank you
I
very
don't know
much.
let me address your first point, the first point about the definition. I will tell you that we grappled with this for a very long period of time. We changed it several times. At some point in our comment, we had a definition that we actually got from the dictionary of what constituted severe or pervasive, and we had words like repulsive, and that there was commentary with respect to that saying we were being confusing, that we shouldn't spell out anything further and leave it as severe or pervasive, because we could look to the common law to assist us in the definition of those rules. And so giving examples, the ABA report did that. They had examples of what constituted severe or pervasive. The problem is examples are really not appropriate within commentary. And so we believe it's important to leave it to the common law. Deborah, do you want to add anything to that?
No, I think it just gets difficult because, you know, for every two examples, there's the counter example and so on. And you aren't on some level writing on a clean slate. There is a significant body of law, and it's not that you're expecting all lawyers to be employment practitioners, God forbid, but there are resources here and they're not obscure. And the standards are, I won't say super high, but they're not trivial. And they're not the kind of things that people fall into unwittingly. I think that fear is exaggerated.
Thank you very much. I'm going to move on to the next question that we have. I'm going to recognize Terry Major. Terry, are you there? You can turn up. There you go.
Muted. Sorry, I was still muted. Thank you for recognizing me. I'm Terry Mazur. I am the immediate past chair of the Women in Law section, and I am now the delegate to the House of Delegates. I'm happy to be here. And first, I'd like to thank you, Ellen, and the committee for doing such a great job with this. We do have some concerns, as you know, but we do endorse the idea of this proposal to amend Rule 8.4G to align it more closely with the ABA model rules. We think that we support the proposed amendments that would include as unethical conduct by attorneys, discriminatory and harassing conduct in the practice of law, not just in the context of the employment relationship, that it expands the list of protected categories and eliminates the requirement for to bring a complaint in the administrative tribunal before a disciplinary proceeding. However, the Women in Law section does object to the inclusion of the severe or pervasive standard in the definition of harassment in paragraph 8.4G3 and the use of the phrase unlawful in connection with unlawful discrimination in 8.4G1. The reason we object first to the severe or pervasive standard in the amended Rule 8.4G is that that standard is not the law in New York. That standard was removed from the definition of harassment in the most recent amendment to the New York State human rights law. And second, that standard is not part of the definition of harassment under the New York City human rights law. To the extent a standard is needed, we suggested that the New York State human rights law does provide a new standard for harassing conduct, which is conduct that, quote, rises above the level of what a reasonable victim of discrimination with the same protected characteristic or characteristics would consider petty slights or trivial inconveniences, close quote. So that could be incorporated into the amended Rule 8.4G3 as a standard. Second, or the next point regarding the use of the term unlawful in connection with discrimination, we propose that unlawful be removed from the rule because as an ethics rule, then Rule 8.4G should provide a greater protection. You could provide a lower standard for this. We did not suggest one. And in addition, as I believe it was Professor Gillers noted in comments, use of unlawful would require a disciplinary committee to reach a legal conclusion about the conduct, which they generally do not do, and could also require the disciplinary committee to decide jurisdictional issues, which jurisdictions law applies. And finally, I just wanted to add in connection with Sharon's comments a moment ago, I don't think activities or events goes too far, defining them as bar activities or events. As you noted, Ellen, so many women have reported that that is where much of this conduct takes place. And since it is, does cover bar activities and professional events, I think it's perfectly appropriate to extend the rule to that conduct. Thank you very much.
Thank you. Is either Professor Yaroshavsky or Ms. Raskin wish to respond briefly?
Yeah, let me just say, Terry, thank you so much. We considered your report, as you know, very carefully. I think we've addressed all of the concerns within the body of the report. I don't want to take additional time here explaining why it is that we decided not to adopt the ABA rule. And I'm not sure that one needs to say more. The only thing I would say was with respect to the law in New York, maybe I didn't make it clear enough. The law in New York is with respect to employment situations where you don't need severe or pervasive conduct to hold someone actionable for harassment. What we added to that's unlawful discrimination, we added a separate provision for harassment for the concern of the professional activities and conduct with respect to court reporters taking depositions, other ways in which lawyers can subject others to harassment. In that context, we believed it was essential to limit the conduct to severe or pervasive.
Thank you. I would now like to recognize Ron Minkoff. Ron, you're muted. Okay, you muted yourself again.
Okay, here I am.
There you
Sorry. This is Ron Minkoff, New York County Lawyers Association delegate and member of COSAC. I wanted to rise in favor of this resolution and this proposal. I also want to start by complimenting Ellen for the amazing work that she did on this. She had to navigate positions from the far right to the far left and everywhere in between in order to come up with a proposal that makes some sense. And as a member of COSAC, I saw the day-by-day changes to this rule as she worked through the various issues that were raised by people. I had the fortune or misfortune to be a member of the ABA Policy Implementation Committee that was initially in charge of implementing Rule 8.4G at the ABA level. And to say it was a failure was an understatement. Only 2 states adopted the rule in its form as the ABA issued it. And there was a great deal of controversy. But on the other hand, what the ABA was trying to do was to make an important statement on behalf of the profession that we can't allow discrimination in all of its various forms to happen in our business, and not just inside our firms, but in the way we interact with clients and court personnel and others. On the other hand, we have to recognize that this is a disciplinary rule and one that will affect lawyers' licenses if they violate it. So the effort that Ellen has made here and that COSAC as a whole has made here to try and focus on conduct that really merits discipline, in addition to making the statement that we need to make as an association, that this is not to be tolerated, that we aren't going to impose all kinds of prerequisites and preliminary requirements like we do under the current rule, is an incredible achievement, and would be an incredible statement by our association that we are in tune with the mood of our various constituent groups in 2021. This is a modern rule, and it's one that will be workable and that will provide guidance both to bar prosecutors and to defense lawyers in dealing with these kinds of difficult questions. So I ask for the House's support for this rule, and again, my compliments to Ellen for the amazing work that she has done.
Thank you. I would next like to recognize Jonathan Ben Asher.
Good afternoon. I'm speaking on behalf of the Labor and Employment Law section. We submitted comments to the COSAC report, which are in the materials. But first, thank you to Ellen for the huge amount of very thoughtful, very diligent work she did on these extremely complex and difficult and critical issues. Ellen and Deborah are both nationally known experts on these issues, and I've known them and admired them for many years. So in terms of the Labor and Employment Law section, we enthusiastically support the report, but we do have one major concern, which I phrased in terms of a motion. It's not entirely clear to me right now whether we did the right thing procedurally, but it's sitting there. And our motion is to remove the severe or pervasive language that's included in proposed rule 8.4G3B. So the Labor and Employment section has particular interest and expertise in these issues. These issues affect lawyers as employees, as employers, as complainants, and potential respondents. The proposed rule implicates the application of federal and state and local anti-discrimination and anti-retaliation law that the courts and our section and the administrative agencies have wrestled with for decades. So those of us in the Labor and Employment section who examined the COSAC report and submitted comments were from all constituencies. It included Chris D'Angelo, former section chair for management. Similarly for management, Michael Bernstein, another section former chair, a neutral Tim Taylor, and representing employees Wendy Lazar, very involved in the ABA proceedings on this, and me, another section former chair. So we all strongly endorsed your recommendations, Ellen. We entirely agree that discrimination and harassment are a major problem in our profession, and it requires this rule change. The rule as it is now is completely outdated, outmoded, cumbersome, and frankly, kind of bizarre. The idea that somebody has to first file an administrative charge with either of the fairly lumbering agencies that deal with these issues or go to court before they can appeal to the ethics committee on some extremely sensitive and personal issues is way outmoded. There are many complainants who can't afford counsel to do this, and there's many complainants who might be extremely sensitive
Wrap up your comments and end with your motion.
to raising this. On the severe and pervasive issue, we agree with the comments from the Women in Law.
Motion. Is there a motion?
Yeah, the motion is to eliminate the severe and pervasive language from the report. We agree completely.
Is there a second to the motion? Seeing no, was it seconded? Okay, so there's a second to the motion. Is there any further discussion on specifically this motion, which we have already heard many comments about? So unless there is somebody who needs to add something new, I would ask that we don't belabor the discussion. Okay, recognize Adrian Holder on this issue.
Good afternoon. This is Adrian Holder. Thank you so much for giving me the time. I first would like to thank Ellen Ushofsky and Deborah Raskin. It's very good to see you all. And I know how hard you all had to work on this. I know how controversial this process has been. And I appreciate the fact that only in New York and within our profession could we have such a wonderful and robust debate about this. I would like to offer an amendment. I am concerned about the part, and again, I do appreciate all the work that's gone into this, and I serve as co-chair.
I'm sorry, Ms. Holder, are you offering an amendment to the motion that's on the floor or to the report?
Amendment to the report.
Okay, so there's a motion on the floor right now with regard to the severe and pervasive language.
Oh, I'm sorry. Yes. So
So do you have any comments with regard to that motion?
I think I support a lot of aspects of what has been in the report, and the severe and pervasive language, I'm okay with that for now. Yes.
Okay. So if you don't mind, I'd like to take a vote on the motion that's on the floor, and then Ms. Holder, we can hear any further comment you may have. So at this time, we're going to put a poll up with regard to the motion that's on the floor to amend the report presented by COSAC to eliminate the severe and pervasive language. Okay, the motion on the floor fails. I would now like to recognize Ms. Holder to complete her comment on the original motion that was on the floor to accept or adopt the report and recommendations. Ms. Holder?
My apologies. So I also serve as co-chair of the Committee on Legal Aid, and we joined in with comments with the Committee on Diversity and Inclusion. I would like to offer an amendment. I do take very seriously this moment that we're in, and in this great state of New York, and looking at everything that has been going on in the past year, that this is the opportunity to embrace true change. One of the things that I would like to offer is that we should remain a progressive leader and not have this initial exhaustion of efforts to obtain declarations of wrongdoing from other tribunals before being able to push forward to get these complaints forwarded. I think all it does is it actually, especially for unrepresented litigants and other folks, that it actually discourages the reporting and increases the harm. And so I would hope that we could perhaps remove that requirement.
So are you asking for a friendly amendment?
Yes, if that would be considered a friendly amendment.
Professor Yaroshavsky, would you like to respond? You're on mute, Professor. Professor is still on mute. Okay, now you're off.
Okay. Hi, Adrian. Is your amendment, I'm not clear what the amendment is, because there is no requirement in our rule of exhaustion. We're eliminating that from the New York rule.
Oh, I am so sorry that I must have misread that. I'm so sorry, Ellen.
That's okay. The current New York rule has an exhaustion requirement. That's one of the reasons we went to the drawing board to change the rule. We agree with you. And can I just say, I really appreciate all the comments and the praise, but It's not just me. We had an excellent subcommittee, David Schraber, who many of you know, my past president, Brenda Dossett, and Justin Chu with the subcommittee, and people on COSAC were very helpful, as was Ron Minkoff and various other committees.
I'm sorry, Professor. So did you accept Ms. Holder's friendly amendment?
I know, I thought
There
she
was
was
no need
going
for
to, she was going to remove it
Okay.
because there is
Thank
no
you.
requirement of exhaustion.
Thank you. I apologize. I was being whispered to, so I apologize for
Okay.
for not hearing that. Okay, thank you very much. Okay, so now I return to the original motion for adoption of the report and recommendations of the Committee on Standards of Attorney Conduct with regard to Rule 8.4G. We are now going to put a poll up onto the screen. Okay,
Right.
it appears that the vote has come in and the motion passes. Thank you, Professor Yaroshavsky and Ms. Raskin for your presentation today.
Thank you all so
Thank you.
much. We think this is a really important step forward for New York, and hopefully the courts will take this very seriously. So thank you all.
Thank you.
Thank you. Okay, we now turn to the report of the foundation. We're just waiting for the president of the foundation to be
Here I
brought up.
am.
Ah, okay. Thank
Last
you,
but
Carla.
not
I
least,
now
right?
recognize Carla Palumbo, the president of the New York Bar Foundation, to report on the work that they are doing. Thank you and welcome.
Thank you, Chair Wallach. I appreciate the opportunity to address the House. And thank you all who are still on the call. I know it's been a very long day. I'm very happy to start my term as president of the foundation. Just as a little bit of background, I'm the CEO of the Legal Aid Society of Rochester, where I've been the bulk of my career. The Legal Aid Society of Rochester is one of the oldest in the country. This year, we're celebrating our 100th anniversary. And I'm very excited and looking forward to bringing my experience in legal services to further advance the charitable work of the foundation and the association through the foundation. I would like to welcome at this time our two new board members, Vincent Doyle, who's past president of the association, and Lauren Sharkey. They will start at their meeting today that will follow this meeting. I very much look forward to working with them. I also would like to welcome two new fellows, judicial district chairs. Co-chair for JD5 is Timothy Fennell. I'm sorry if I mispronounced your last name. And district chair for JD9, Tamara Mitchell. So thank you for agreeing to serve in those capacities, very important positions. I would like to thank outgoing President Leslie Rosenthal for her 3 years of tireless service to the foundation. As president, she navigated us through some challenging years. I'm very grateful for her leadership, her strategic view of the work that we do, and her steadfast promotion for the rule of law. A very notable was the partnership that she forged for a webinar between the foundation and the association on the rule of law that was just completed this June 3rd. I would like to thank the House of Delegates today for the passage of the resolution ratifying the Memorandum of Understanding. I thank the leadership of both organizations and the negotiating teams for getting us here today. I wanted to reiterate the foundation's commitment to working in a positive way with the association to ensure that both organizations remain strong and viable, and that our next steps, that we move forward jointly on our next steps. At this point, I would like to quickly outline my vision and the initiatives that the foundation will be working on over the next year. First and foremost and key will be the development of a fundraising plan and campaign jointly with the association to strengthen both of our organizations. One of the second initiatives that I'm very interested in us starting and completing this year is looking at how to best measure the impact of the charitable work of the foundation. What is the effect that we're having, and how can we best describe and explain that effects with the community and the membership of the association? To that end, I look forward to working with the association to spotlight the good work of attorneys in this community. And we will achieve both the fundraising aspect and the strategic plan going forward with the retreat that we plan to hold this fall, hopefully in conjunction with the in-person meeting in October. Our grant program opens September of this year. Last year, we had over 100 applications, and I have no reason to think that we won't have as many this year. My goal is to ensure that we fund a program in every judicial district so that we can assist the broadest array of people in the community. But in order to do that, I need your help. I need each of you that represent a judicial district to share the opportunities for grant funding with the not-for-profit agencies and legal services in your district so that we can cover a program in every JD. We currently have programs in 12 of the 13. And right now we're in the middle of our COVID-19 Day Challenge, which is an online challenge that I think the link is in the chat or in the questions and answers. But let me just explain a little bit about that. When COVID-19 hit in 2020, the Bar Foundation quickly established the COVID-19 Legal Relief Fund. With your generosity, we raised nearly $100,000 that was in turn distributed as grants to organizations throughout New York State devoted to helping underserved. Your support was very important, and in the words of two of our grantee organizations, helped with some very significant, help provide support in some very significant areas of need. One was with survivors of domestic violence, providing virtual legal information and advice and representation during the pandemic. Many of those survivors were sheltering in place with their abusers. And the other was from an organization in Western New York that found that due to the pandemic, people were struggling with healthcare issues, unemployment benefits, and that many of the older adults were having difficulty planning for their long-term care. The support from the Bar Foundation through the COVID relief program was able to help them in that area. There's no question that the impacts of COVID-19 continue. I see it in my practice today. They'll continue into this year and in other areas besides those that I've just talked about that include housing and consumer debt. So we've created a challenge that's still open. It's still out there. It's a JD challenge amongst the different judicial districts. So I invite everyone here to consider clicking on the link in the questions and answers and raising money for our COVID-19 Day Challenge. To date, as of this morning, we've raised $11,520. And in competition are the top three districts, JD1, who have raised $2,850, JD7, $2,125, and JD5, $2,025. There's only $725 that separates my hometown district of JD7 from taking the lead. So JD7 people out there, please donate so we can win the challenge. Several districts are tied. This is a great opportunity for you to make a difference and to give in under your district, help your district take the lead on the challenge, and then help us help people impacted by the ravages of COVID-19. I would like to conclude with telling you how much I very look forward to this governance year, the opportunity to grow the foundation's charitable giving, to measure our success, and to strategically look at the next 3 years. Most importantly, however, I look forward to doing this great work in collaboration with all of you of the association, because together we are stronger. Thank you for your time, and I look forward to an in-person meeting in October.
Thank you so much for your presentation. We now move to the administrative items. There is only one. The bylaws require that the House to confirm the appointments of the Finance Committee. President Brown has appointed Drew Draglum and Michael McNamara. May I have a motion to confirm these appointments?
Second.
Is there any discussion on the motion? On this motion? Okay. I see that Mr. Richmond would like to speak to this motion. Mr. Richmond?
Madam Chair, I want to be recognized as the new business. I have nothing on this motion.
Okay, I think I see you now. Mr. Richmond, are you speaking to the
Madam Chair,
motion
no,
regarding the finance?
no, I wanted to speak on new business. I have nothing
Okay.
on this.
So if you just wait one moment for this motion to conclude. Thank you. Okay, so having no hands raised and no discussion on the motion to approve the appointments to the Finance Committee, there's going to be a poll that's going to appear on your screen. Please cast your vote. The appointments have been approved. The motion carries. We now are in a position to turn to the matters of new business. Anybody having new business to bring before this House, please indicate by raising your hand in the chat. I mean, in the Q&A, I apologize. Okay, Mr. Richmond, you indicated that you had a matter of new business to bring before the
Well,
House.
it's either new or old business. At the April meeting, the House passed a resolution to create a committee to review the question of certification of Supreme Court justices, which was supposed to report back to both the Executive Committee and the House at the June meeting. That didn't happen. But however, it does appear from the minutes that at an Executive Committee meeting in May, they did present a resolution calling for the association to support the bill that would require the mandatory certification of qualified 70-year-old Supreme Court justices. With 18 members listed and one first name, but by a vote of 10-10, the committee didn't agree. So I'm going to move now that pursuant to the authority vested in this House by Article 5, Section 1 of the bylaws, that the State Bar Association call for the enactment of S 4379 and Assembly 6044, providing to amend the judiciary law to end the discretionary certification of 70-year-old justices for certification. And it's timely because the Assembly and the Senate may be back either at the end of this month or definitely in the fall to also deal with reapportionment.
Dave, I do thank you for your enthusiasm, but I do want to point out that the governor signed legislation. I believe it, or maybe it passed. Has been signed. Yeah, I believe it both passed and has been signed by the governor.
That, okay, I mean, I checked as of this morning, it's not listed on LRS.
One moment.
They did create the new Supreme Court justices.
All right, Steve, let me retract my statement. It has passed both houses. It has not been signed yet. It's on the governor's.
Then I would modify it that we would urge that the association come out in support of the bill and urge the governor to sign it.
Okay. Steve, at this point, in the April 10th meeting, there was a motion to amend the resolution that was offered by John Barron's regarding the certification of the judges. There was a motion made by Mr. Richmond that was not seconded. A committee was formed. The motion in April, on April 10th, was that a committee to be formed promptly to report to the executive committee in the House at the June 2021 meeting in order to consider whether to file an amicus brief in the New York Court of Appeals in the Gersimer litigation challenging the denial of certification for 46 otherwise eligible senior New York Supreme Court justices. Such a brief would provide the opportunity to put before the court and the New York State Bar Association its policy on the judicial retirement as it relates to the issues in dispute in the Gersimer litigation. The second part of that motion was to consider whether to support legislation introduced in the Senate and the Assembly to eliminate the discretionary denial of recertification of the New York Supreme Court justices and advise the New York State Bar Association in this regard in the next 30 days, so it would be in time to be heard during the current 2021 legislative session. That committee was formed. They reported to the executive committee, as you indicated. The executive committee heard their report and a vote was had. The legislation that is at issue has passed both the Senate and the Assembly at this point in time. So I believe at this point, the fact that this matter has been resolved, your motion at this point is out of order, as it was already raised at the last.
No, I never raised to urge the government to tell the governor to sign it because OCA may come out against it. I think the state bar should be on the record urging the governor to sign it. This is an entirely new matter. The legislature has enacted already. It has passed the bill. Now it's before the governor. There's going to be a comment period. And I think the association should file a comment in support of the bill. And that's the motion.
Is there a second to Steve's motion? Okay. So hearing a second to the motion, is there discussion on the motion? Okay. Mr. Richmond, are you objecting to my ruling of your motion out of order? And you asking for my appeal of my motion?
Stated my motion. My motion is to do, which has never been considered, the state bar communicate to the governor to support, to recommend his signing of the passed bill. As opposed to the motion that I made in April was to have the association endorse the legislation. The legislature had the wisdom to act without our advice, but now we should give that advice to the governor.
Mr. Richmond, are you appealing my ruling as the matter out of order?
Yes, I'm appealing then the ruling of the chair because again, the bylaws clearly make it. And again, this was brought up as new business in April's meeting. I guess if we don't want to be in a position of opposing the OCA, that's the attempt of the chair now to rule it out of order.
So an appeal of my ruling is a vote that has to go to the House. So at this point, I would ask for a vote of the House with regard to my ruling, Mr. Richmond's motion as out of order, as the matter has been addressed at the last meeting and the actions were taken and the legislation has now been passed by the two houses. Okay. So we are clear, so the vote is clear. If you vote nay, then you are in support of my ruling. The nays have it by, need my glasses, 56%. My ruling to rule your motion out of order holds. Are there any other matters of new business before the House? Okay. Past President Bob Ostertag, you can unmute yourself and turn your video on.
You're muted, Bob.
But Mr. Ostertag, you're still muted.
You're
We still
muted.
can't hear you. Yeah, Bob, we can't hear you. You have to click at the bottom of your screen on the little microphone.
Tom, you can't unmute him?
At the bottom of the screen, there should be a microphone on your right-hand side. At least that's where it is on my screen. Is it? No, it's. If I'm We still can't hear you, unfortunately.
He doesn't know where it is.
I know. Would you like to type into the Q&A your question or your matter if you can't unmute yourself? We still can't. Oh, we got it. Yes, you're off. All right.
How did that happen? What did I do to deserve that? I'm a past president and therefore a member of this House. The name Diane O'Leary will appear in the minutes of this meeting. She is not a member of the House. I'm using her computer, and so her name may appear. It should not. My name should take her place, and it should appear. And I just wanted to report that so that whoever records this meeting can make that correction.
Okay, is that the matter?
That's it.
Oh, okay. Well, we see your name, so thank you so much, though, for clarifying. And it's
Okay.
always good to see you.
Thank you.
Thank you. I believe that past President Tom Levin also had his hand raised for a matter of new business. I'd like to recognize past President Levin.
Thank you. I was going to make a motion to table Mr. Richmond's proposal, which is now unnecessary. So thank you.
Mr. Levin, we can't see your video or hear you.
I'm sorry, it should
Okay,
be
you're
on
coming
now.
on. Now we
No,
have you
no,
now.
I had raised my hand previously because I intended to move to table the previous matter that was discussed, but it's not necessary since it was ruled out of order and the chair's ruling sustained. Thank you.
Thank you, Mr. Levin. Okay, are there any other matters of new business before this House? Okay, seeing no further matters, at this point, we move to adjourn, and I appreciate everyone's indulgence in us going over time. Thank you so much. Do I have a motion to adjourn?
So moved.
Second.
All in favor? You get to do a poll. 100%. Have a wonderful day, everybody. I would like to announce that, oh, I forgot to announce the next meeting. But anyone who's still on, I apologize. The next meeting will be in Cooperstown in person or virtual, your choice.